and indulgence to mention, my lord, new chamber application in connection to execution matter for inclusion in the list, my lord. The execution is filed within 2 years, my lord. Grateful, my lord.
I have execution application. This is, my lord, award dated, my lord, 30th August 2011. And, my lord, because of pendency of section 34 application, but this my execution application was adjourned sine die. My lord, the section 34 application was dismissed on, my lord, August 25, my lord. My lord, petitioner, my lord, partner, senior partner is, my lord, 81 years old, my lord, and 2 crores 76 lakhs is involved. But may your lordship kindly allow this for inclusion and, my lord, give some priority, lordship.
Why should I give any priority, sir?
Lordship.
Why any priority?
My lord, senior citizen, my lord, he is 81 years old, my lord, the person.
And my lord, the only senior citizen in this court.
And, my lord, more than 2 crores 76 lakhs involved, my lord.
We'll see.
My lord, may I be permitted to mention?
May I have your lordship's kind leave to mention a matter not in my lord's list. This is a section 29A application, appointment made by this honorable court. We had approached, my lord, the learned commercial court at Rajarhat, and then we didn't, my lord, move the matter in view of the latest pronouncements. My lord, kindly permit it to appear tomorrow. Tomorrow is the arbitration. That application was filed just after time. This is also after time. So, my lord, if I am not able to persuade your lordship to pass an order of extension tomorrow, the whole arbitration schedule will be completely, my lord, gone. That's the only urgency. I'm being very candid to your lordship. If your lordship...
Mr. Chaudhary, you had already moved the court, the commercial division court at Rajarhat.
No, actually, that was another matter which I withdrew because I had...
Yes, that's right.
This is another matter where it had been filed. So we didn't move it. We are going to move your lordship with an undertaking to withdraw that matter. That matter has not been moved once.
No, but what is the urgency?
My lord, arbitrations tomorrow, my lord. That's the only thing.
It can wait for 2 weeks.
It can. If your lordship indulges us, otherwise it can wait. There's no urgency.
Let's wait.
With my lordship's permission, may I mention another section 29A petition, my lords? It was supposed to be listed today, my lords, but somehow it hasn't been listed. So, my lordships, I'm an outstation counsel. If my lordships can have it today or...
I didn't follow you. Which petition was supposed to be listed?
My lordships, a section 29A petition.
Yeah.
Notice was issued. The respondent was directed to file a reply. Pleadings are...
So how were you so sure that the matter is going to be listed today?
No,
Who told you?
It was fixed for today in terms of the last order dated 15th of September 2025. It was supposed to be listed. But it is not showing in the list today, perhaps because of the change of roster, my lords.
Nothing of that sort. You have to follow with the registry.
I have been informed that my lordships to mention the matter and then only the matter will be listed.
Matter is already there in the list. It should have been put. Date जब देता है तो matter क्यों नहीं लगेगा?
Then my lordships may...
My lord,
putting the matters when
my
the
lord,
All right, very well. Top of the board, possibly.
My lord, may I be permitted to mention, my lord, 34 application challenging the same award. I have filed an application. My applicant has filed a section 34. May it be listed, my lord?
Not right now.
my lord, may I be permitted to mention the execution petition in respect of the arbitral award has already been listed, and we have preferred an appeal. If the appeal and the execution could kindly be heard together, my lord.
No, madam, we'll see. There's no urgency.
My lord, our appeal would be rendered infructuous if the execution is heard before. It is already listed. There is
The
an order.
execution is listed, right?
Yes, it is 4th November. An order has also been passed to direct service upon us, but our appeal has not been included in the
Nothing becomes
list.
infructuous, madam. Nothing becomes infructuous. Yes.
May I have your lordship's kind leave to mention a matter in a section 29A application. My lord, your lordship was pleased to
we were not there. Malad, I'm being very candid. I'm for the respondent. We missed the matter. But when we checked up the Malad, the live streaming, your lordship had given 3 months extension, but in the order we find it 6 months. So if your lordship has changed your lordship's mind, that's a different thing.
3 months.
3 months because it says
So
6
whatever it is, whatever the order has been passed,
But
sir.
in open, when we check the live streaming, my lord, your lordship has, I have personally checked, my lord, your lordship has said
Whatever
3
it
months.
is. Sir, whatever we say on the live stream doesn't mean we can't change our orders.
That is what
all
I
right?
said. That is what I said, my lord. With utmost humility,
Whatever
I
the
said
order
that.
has been passed has been passed.
I said that my lordship may have changed your lordship's mind.
May I have your lordship's kind leave to mention one matter for inclusion, my lord. In this matter, AP 759 of 2023, my lord, all the pleadings have been completed and thereafter the matter was supposed to come on 4th January 2023, my lord. But it has never come back there, 2024, but thereafter the matter has not been listed, my lord. The only urgency I'm facing, my lord, there was a section 36 application for stay of the award. I am the award debtor, my lord, and pursuant to order of my lord justice Moushumi Bhattacharjee, we had to submit a the deposit of 50 lakhs, my lord. That is the urgency only I'm facing, my lord. If the matter can be heard,
No
my lord.
urgency,
All
madam.
proceedings-
No urgency.
To mention a matter, your lordship, bank guarantee for extension of bank guarantee, your lordship. It has expired 26th of September, your lordship.
It would have been renewed on its own.
Lordship, we have your lordship.
You didn't do it on time.
Yes, your lordship. Need be listed, your lordship. Otherwise,
Take this.
May I have your lordship leave to mention a matter for inclusion, a chamber application for
No
inclusion?
inclusion right now.
My lord, may I be permitted to mention a section 34 application, my lord? It's of 2018, my lord. That's the only reason, my lord. May it be, it is listed. It is in your lordship's list, my lord.
They
Then
will come up
ensure-
whenever it's listed.
lordship, for non-prosecution.
With the lordship leave.
It will come up.
With your lordship leave, my lord, may I mention matter?
Application, right, with a stay application, my lord, was moved, my lord, last week. The hearings were concluded and my lord directed the parties to file the written notes of argument by Monday. My lord, the matter is not in the list. So, my lord, can the matter appear in the list or my lord, should we file in the court?
File your written submission.
My lord,
May I have your
with your
lordship?
lordship leave, may I mention a matter, my lord? This is section 14. We have filed in September, my lord. The arbitral tribunal has said that it will not stay the proceeding if the matter is not heard or stay is granted, my lord. The arbitral proceeding is 26, my lord. He is proceeding, and we are challenged under 12.5, my lord. The grounds are on 12.5, section 12.5 of the Arbitration Conciliation Act, my lord. This is a section 14, my lord. Kindly be listed, my lord, before, because if it is not stayed, the arbitral proceeding will go on, my lord. The urgency is that, my lord.
Yeah, let it go on, sir.
My lord, the urgency, my lord,
Yes.
we have objected under 12.5, my lord. He doesn't have the jurisdiction to proceed with the matter, my lord. My lord, kindly keeps it. Yes, yes.
This is a very unfortunate situation in this matter. After taking up the arbitration reference from the court, the gentleman is my lord, taking up matters against the claimant and appearing in court, which is barred under the law. So, my lord, when we showed that the judge orders, he said that I'll proceed with it unless the matter is taken up by the court. So we are in a precarious situation, my lord. This is unheard of, my lord. Post reference appointment from the court, matters being taken up against the claimant.
Against the claimant.
Against the claimant. Post reference, my lord.
Arbitrator is a lawyer.
Yes.
All right, give it.
Very
May I have your lordship? May I have your lordship leave to mention one more matter for upgradation, lordship?
Upgradation not happening.
My lord, may I allow to mention 3 matters, my lord. The matter has been settled and an NOC has been issued by the award order.
Non-prosecution.
Lordship, may I be permitted to mention 2 matters for application. The another question. There is a direction from the Honorable
Sorry, madam.
May I
come.
Yes.
May I be allowed to mention 12 connected execution matters, lordship? There is a direction by the coordinate bench to pay 1 lakh rupees, to pay 10 lakh rupees within 13th of November, and the matter was supposed to be listed on 14th of November, lordship. The matter is not listed and the award debtor has also not paid any money, lordship. There was a consent order in 2023 whereby the total...
No urgency in this matter.
Lordship, may I be permitted,
No urgency.
Lordship, may I be permitted to mention a matter for non-prosecution?
Mention one contempt application, your lordship, for inclusion. Appellate side.
Appellate side.
My lord, may I be mentioned for content application in inclusion?
May I permit to mention what content
No
of
inclusion right
applications?
now.
My lord,
Yes.
may I be permitted to mention execution matter for upgradation, my lord? It is item number 495.
No
My lord,
upgradation.
may I just place the urgency? It is
Sir, no
2024.
upgradation right now. Wait for some time. Madam, I heard you. Matter is pending here, right? Yes. So what is the urgency?
My lord, there are two applications.
Yes. Yes. Yes.
I think it's going to the next objective and directed that the High Court has heard of the matter.
Very good. So High Court will hear the matter whenever it will come. Our boards are not run by other courts. Huh?
So may I permit to mention?
Yes.
This is the contempt application. State respondent has not complied with your lordship's order.
Sorry?
State respondent has not complied your lordship's order.
Contempt on what? Appellate side?
Yes.
Give it. Give it.
Your Lordship, may I mentioning a matter for the execution application for upgradation? Your Lordship,
No
in this
upgradation,
matter,
sir.
no
Not
section
right.
36 application has been
Not
filed,
right
Your
now.
Lordship.
Not right now.
Your Lordship, the petitioner is 80 years old person.
Not
Your
right now.
Lordship.
Wait for some time. Wait for some time.
Okay.
Call out the list.
My 29 application, my lord, the service is on record. We have served on the other side, my lord.
Give the
Yes, my lord, the date of the reference, my lord, first is 19th of April 2024.
19th April.
Yes, my lord. And my lord, the time, my lord, for 1 year, my lord,
When
expired
was the
on,
arbitrator appointed?
my lord, the arbitrator, এটাই appoint হয়েছিল তো? The arbitrator was appointed, my lord, by the order of my lord. That's my lord on date বলো?
3rd.
That's not annexed, I find, my lord.
No, it is 3rd of April.
Annex করোনি কেন?
Mention in the previous.
You should have annexed it. My lord, 3rd of April 2024. Although not annexed, it's in the list of dates.
It's
my lord.
there.
Yes.
3rd of April.
Then, my lord, the mandate expired on 17th of September 2025. But this 6 months cannot be, my lord, extended because, my lord, it is proceeded ex parte before Justice, my lord, the ex-justice, my lord. Because, my lord, she gave a lot of notices, but they have not appeared, my lord. So 6 months couldn't be extended with consent. So it has to be by court, my lord.
All right. Take down. The present application has been filed by the petitioner under Section 29A of the Arbitration and Conciliation Act 1996, seeking extension of time for conclusion of the arbitral proceedings and for publication of the award. Arbitral award, full stop. This court, while order dated 3/4/2024, appointed the sole arbitrator to adjudicate the dispute between the parties, full stop. The matter proceeded ex parte.
Sorry.
The matter proceeded ex parte before the tribunal, full stop. The ex parte evidence and argument on behalf of the petitioner was concluded and the matter is now pending for publication of the award, full stop. The current mandate of the arbitral tribunal expired on 17/9/2025, full stop. Hence, the petitioner has preferred the present application seeking extension of the mandate of the arbitral tribunal, full stop. Upon consideration of the submission and the materials on record, this court is satisfied that there has been no undue or unwarranted delay on part of the arbitral tribunal in conducting the proceedings, full stop. Accordingly, the mandate of the arbitral tribunal is hereby extended for a period of 3 months. Tribunal for a period of 3 months from today, full stop. It's just for publication.
Only for publication. That is
1 month.
1 month. My lord, the pressure that they have.
The arbitral tribunal is requested to ensure that the arbitral that the award is published within the extended time period, full stop. With the aforesaid observation, the present petition stands disposed of.
Grateful, my deeply grateful.
Your Lordship, this is my section 29A application. Here's my affidavit of service, Your Lordship. Your Lordship, in this matter, the petitioner supplied some goods and there's a dispute regarding the outstanding amount against the supply of the said goods. 17 January 2023, this court appointed an arbitrator, which is at page number 17, annexure A, Your Lordship. Your Lordship, pleadings completed on
Annexure?
A, page 17. Your Lordship, pleadings is completed on 7th May 2024. Presently, the stage of the final hearing, hearing is we started, and the mandate of this arbitrator, Your Lordship, expired on 6th November 2025.
Take down. First paragraph same hoga. First paragraph would be the same as in the earlier order. Then take down this court-wide order dated 17 January 2023, appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 7/6/2025. Full stop. With the consent of the parties, the mandate of the arbitral tribunal was extended for a period of 6 months. Full stop. Now the mandate has now the mandate expired on 6/11/2020. 6/11, right?
6/11, Your Lordship.
6/11/2025. Full stop. Now the mandate has expired on 6/11/2025. Full stop. The arbitral tribunal has conducted more than 27 hearing and the matter is listed. It's a final argument stage.
Final argument.
And the matter is at the stage of final arguments. Full stop. In view thereof, the petitioner is seeking an extension of the mandate of the arbitral tribunal. Full stop. Upon consideration of the submission and the materials placed on record, this court is satisfied that there has been no undue or unwarranted delay on part of the arbitral tribunal in conducting the proceedings. Full stop. Accordingly,
Your Lordship, I will pass necessary orders, my Lord.
उससे पहले एक line लिख लो. Learned counsel for the respondent states that he has no objection to the mandate being extended. Full stop. उसके बाद डाल देना. Accordingly, this court extends the mandate of the arbitral tribunal further for a period of 6 months.
6 months.
6 months from today. Full stop. The arbitral tribunal is requested to ensure that the arbitral proceedings are concluded and the award is published within the extended time period. Full stop. With the aforesaid observation, the present petition is disposed of.
Much thank you.
This is my section 9 application. Receiver was appointed by this honorable court. She is to file a report. My lord, the order was of 9th of June 2025.
What steps have you taken, arbitrator?
Yes, my lord, my lord, I am in a little precarious situation. Is that, my lord, I am seeking sale of this assets through my lord because of the reason the arbitrator was appointed on 9th of June 2025.
Yes.
Now, my lord, we were a little late in, my lord, informing him. But, my lord, he is, because of the opinion that earlier, my lord, the reference was intimated by the honorable court.
Yes.
And for a disclosure. Now, my lord, this stopped all of a sudden. And, my lord, it was to be, my lord, nobody was aware of it. So, he is of the opinion that, my lord, there has to be a fresh mandate passed by the court in his favor. Now, that is little unusual because, my lord, the act does not say so. The act is silent about who is going to inform. It's not the courts nor, my lord, it has to be informed by some party.
That's all.
Now, my lord,
the order has to be communicated to him. That's
yes.
Malad, it does not, it
Doesn't
does
matter.
not say the court has to inform. Court has done so in previous occasion, Malad, out of Malad, their own Malad efforts. That is different.
Hmm.
Now, Malad, the situation is the arbitrator, Malad, who is a retired justice also, Malad, says that no, I will not proceed or enter upon the reference until you get a fresh order from the court of my mandate. Now, Malad, that is not possible. Once appointed, cannot, my lord, unless he recuses himself. Now, Lord, I was only beseeching my lord this, that my lord, in a section 9 at this stage, it is improper to take an order from my lord for sale. If your lordship, my lord, disposes of this application by directing, my lord, the arbitrator to, my lord, take up the proceedings in a section 17 order if I find. So that, my lord, that would regularize him. My lord, he is of the opinion that unless a fresh mandate is given, I will not proceed. That I am in a limbo now, my lord.
20th August আমরা নোটিশ দিয়েছি নোটিশ লেখাই রয়েছে
And my lord kindly takes once, my lord, section 23(4).
23(4).
Yes, my lord.
Yes.
Now 23(4) says, my lord, the statement of claim and defense under this section shall be completed within a period of 6 months from the date the arbitrator or all the arbitrators, as the case may be, received notice in writing of their appointment. So, my lord, his 6 months will not start. But, my lord, the learned arbitrator is of the view that it has started and therefore a fresh mandate has to be taken. But that's not the case. The act is very clear. From the date the notice is given, 6 months would start. So, my lord, if lordship, my lord, disposes this off by, my lord, giving, my lord, a direction, my lord, that I will have the release before the arbitrator, my lord, that would suffice. Because it would be completely improper to take an order from my lord now. Because, my lord, cannot be in season. Kindly, my lord, records that. I'll show that to the arbitrator and file a section 17 and না 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 ও রেকর্ড করেনি ও বলছে আমি ঢুকবোই না তো রেফারেন্সে কোথা থেকে বলছে না তো কিছু বলছে why will I enter reference আছে দাও আপনাকে ছেড়ে দাও ছেড়ে দাও ছেড়ে দাও ছেড়ে দাও ছেড়ে দাও ছেড়ে দাও kindly, my lord, records this, my lord, and directs us to proceed before the arbitrator so that I can show this and proceed before him.
Take down. The learned receiver has submitted a report stating that the possession of the hypotheticated vehicle was taken on 16/9/2025. The petitioner, this is kept in the custody. You are paying any rent for it?
He is kept, my lord. Yes, we are paying the rent, my lord. The yard rents are paid by us, my lord.
The petitioner is directed to pay. How much are you paying? Rent. Are you paying rent directly or through the?
No. Directly to the, my lord, garage owners.
All right. वो छोड़ दो.
चाहिए होगा तो rent तो दाओ. अच्छी चीज़ कहाँ अच्छी?
The report is. The report also indicates that the asset has been kept under the custody of Biram Automall Panvel.
আপনার এন্টার করতে আর কোনো অসুবিধা নেই আগেও ছিল না এখনো নেই হ্যাঁ
Full stop. In the present matter, this court had granted an interim order in favor of the petitioner on 16/4/2025. Full stop. In terms of section 9(2) of the Arbitration and Conciliation Act 1996, the arbitral proceedings are required to commence within 90 days from the date of the said order or within such period as may be determined by the court. In view of the above, the arbitral in view thereof, the present petition is disposed of with a direction to the learned arbitrator to treat the present petition as an application under section 17 of the Arbitration and Conciliation Act 1996 and pass appropriate orders in accordance with law.
যেতে হতো উনি বলছেন এরকম কোনো স্ট্যান্ডার্ড প্র্যাকটিস আছে বলে আমি জানি না
Full stop. वो पहला वाला लाइन हटा दो.
ठीक है খুলে দেখো
Or in fact, my lord, the learned arbitrator to this extent, as I said, gave a letter also, which my lord, I can hand over, my lord, saying that I will not proceed. Because
What is the point of sending this application to him? Then he will not proceed. If the arbitral
no, my lord, if this is sent to him, my lord,
but if the arbitral tribunal is not constituted,
it is, my lord, under the act, it is constituted. Only that, my lord, he has a, my lord, notion that, my lord, the 6 months has started. So that is not true, because, my lord, the 6 months will start from the date the notice has been given to
or
him.
then the learned counsel of the petition submits that the arbitral tribunal has been constituted.
Yes, my lord, by an order of this court,
Yeah.
9 June 2025, by an order of this court.
Has been constituted. Full stop. उसके बाद कर देना in view thereof the present petition is disposed of करके. ठीक है. In view thereof the present petition is disposed of with a direction to the learned arbitrator to treat the present petition as an application under section 17 of the Arbitration and Conciliation Act 1996 and pass appropriate orders in accordance with law. With the above direction, the present petition is disposed of.
এটা ন্যাচারাল বলা আছে অ্যাক্টে এটা বুঝিয়ে দেবো আমার মিটিং এ হ্যাঁ তো এটা 17টা ফাইল 17 তো ফাইল করবি তোকে তো ডাকবেই ও গ্রেট আমি মেনশন করবো তোর কাছে ওর কাছে 17টা ফাইল করে গ্রেটফুল ম্যান 17টা ফাইল করে মিটিং ডাকবে হতে পারে
But item number 4, I beg to appear virtually, my lord. But am I audible to you, my lord?
Yes.
For the respondent, my lord, I'm appearing.
Item 4, I am the receiver. I am for the petitioner, my lord. On the last occasion, your lordship, the respondent has submitted that there is a scope for settlement. Your lordship, I have taken instructions. The parties had entered into a memorandum of understanding for the admitted amount that was due and payable, your lordship.
Yes.
Now, my lord, the first equated monthly installment had been paid, but the second equated monthly installment, they have again failed. There are 3 secured assets, your lordship, out of which one could be traced. They were also, according to those terms, were supposed to disclose the location of the other 2 assets. They have not. We have an order of injunction, my lord. Under these circumstances, I have received instructions from the client. They are apprehensive to release the assets or proceed with the memorandum of understanding, considering that there is a violation already, your lordship.
So this is an interim measure. What about the constitution of the arbitral tribunal?
Your lordship,
Nothing has happened.
Section 21 notice has already been issued, my lord. We are taking steps for filing the
When
section
was
11.
the order passed, madam?
Which order, your
Interim
lord?
order.
Interim order
30th of July.
21st April 2025.
So from 21st April, when did you give the 21 notice?
Your lordship, it was in August 2025, my
So
lord.
what are you doing? I'll dismiss these petitions, I'm telling you.
My lord,
You're
understand.
dragging your feet, nothing else.
Your
Come back
lordship, in
next
the
week.
meantime, your lordship, in the meantime, there was a chance for
Madam-
settlement, my lord, which is why it got further delayed, your lordship. But then again, that settlement now
Don't-
has failed, so we'll proceed, my
Under the
lord.
garb of these interim measures, don't linger on with the arbitration proceedings.
I understand, your lordship. I have also advised my lord to immediately take steps for appointment of arbitrator, my lord.
Come back next week.
My lord, may I, my lord, make
that you have
one suggestion?
constituted the arbitral tribunal will dispose it off.
My lord,
Great,
may I make one small
Yes.
suggestion? My learned friend is correct with the dates, whatever facts she's placed, it's absolutely correct. I was only making, my lord, one submission. My lord, there's a memorandum of understanding that has been arrived at by and between the parties. It's a signed document. She's right. There are 2 installments that was supposed to be paid prior to today. The first one, my lord, is close to, my lord, 14 lakhs. That's been paid already by me. The second was supposed to be paid on the 11th of November. Today we are on the 16th of November. I was only making one submission. I am undertaking, I have taken instructions from my client. I am undertaking to make that payment within a period of 7 days. My lord, there's one out of the 3 machineries assets, my lord, one is in the custody of the petitioner. My lord, that is required for running of my business. That's one of the essential machineries. I was only suggesting this within 7 days. I take possession of that. I make the payment of the second installment. That's the only installment left. There is nothing else to be paid. Only one more installment. And
Go
some
and
amount of-
discuss all this with her, not in the court.
Grateful.
I'm not here to settle your disputes.
No, I'm saying that this can be disposed of. This application can be disposed of with the observation that I'll comply, undertaking given.
Come back next week.
Grateful, your
Learned counsel for the parties. Praise for an adjournment. Let this matter be listed next week.
Court of the receiver has
Rep-
submitted in previous day.
Yes, that must have come.
But one last indulgence I'll pray for, my lord. There are 2 machineries which are still with me. The receiver, my lord, was directed to take possession of all. May I only, my lord, beseech your lordship to request direct the receiver to not take possession of the other 2 machineries while we are discussing.
Make the payment.
I'm grateful.
Closure also made.
Item number 5 on behalf of the petitioner lordship. On the last occasion, your lordship had directed to serve upon the respondent number 1. Once again, your lordship, I have the affidavit of service. It has once again come back with the endorsement addressee left without instruction. Affidavit of service. Vide an order dated 25th of August and order of stay was already granted in favor of the petitioner, your lordship. So far as the asset is concerned, not to create or disposes or create any third party interest over the proper asset. And it is on instructions. I'm saying that the section 21 notice is supposed to be sent by this week. The time period is till the end of this week. It is going to be sent by this week. The only other prayer that is remaining is an appointment of a receiver if your lordship desires. But the service upon respondent number 1 has not been possible. It has come back with endorsement, addressee left without instruction.
That is not good service.
Yes, your lordship.
Then do a publication.
We'll do a publication, your lordship.
Learned counsel for the petitioner seeks and is granted. 2 weeks, 3 weeks,
your lordship.
2 weeks. 2 weeks time.
Your lordship, just one thing, the
To
order of injunction expires on 30th of November. The order of injunction expires on 30th of November if it can be extended till the next date only. There is an order of injunction passed on 25th of August.
And since then you have not even sent a section 21 notice.
That has not been sent, your lordship, but on instruction I'm saying it is supposed to be sent by this week. The 90-day time
I'm not going to entertain these petitions at all.
I understand, your lordship.
We are not here to give you interim protection. I'll vacate all interim protection if in 90 days you are not going to constitute the arbitrary tribunal. And there's no it should be done before you come here next week.
Definitely, your lordship. Definitely, your lordship.
We are keeping it after 2 weeks.
Yes, your lordship.
Which is that order?
25th of August 2025. I have a copy in my hand, your lordship wants to say.
The order of injunction granted by this court by order date 25th August 2025 is further extended for a period of 4 weeks.
Gratefully, lordship. Your lordship, any specific date may be fixed because for paper publication, I have been informed that a date.
How much time?
Your lordship, 2 weeks, 3 weeks, or 4 weeks, anytime your lordship fixes.
2 weeks.
Yes, your lordship. Grateful.
Okay.
This is my application under section 9, your lordship. Pursuant to your lordship's last order dated 4th of November, we had once again written to the post office. It appeared in the previous affidavit of service, Islam Dinajpur SO, and your lordship had inquired what does SO means. And we had stated SO means the local post office. Thereafter, we have written to the concerned post office. They have confirmed that the item stands delivered.
Delivered.
I'm handing up the affidavit of service. At pages 7 and 8, the tracking receipt is annexed.
Take down. The petitioner has preferred the present.
At the bottom of page 8. And this is my section 9.
present petition under Section 9 of the Arbitration and Conciliation Act 1996, seeking interim protection, restraining the respondent from utilizing, dealing with, alienating, transferring or creating any third-party right in respect of the push carts, right?
Push cart, ice cream push cart, and the refrigerator.
Push carts and deep freezers as detailed in Appendix B of the push cart agreement dated 15/6/2024 executed between the parties. Full stop. The petitioner has also sought an appointment of a receiver to take possession of the said push carts and deep freezers. Full stop. It is the case of the petitioner that, pursuant to the said pushcart agreement dated 15/6/2024, the petitioner handed over 10 pushcarts and 10 deep freezers to the respondent. Full stop. Owing to disputes that arose between the parties, the petitioner terminated the said agreement by letter dated 8/4/2025, calling upon the respondent to immediately return the said equipment. Full stop. However, the respondent failed and neglected to do so and has allegedly been using the said pushcarts and deep freezer for selling ice cream products of competing brands. Full stop. The petitioner, therefore, invoked the arbitration clause by notice dated 19/5/2025 and has now approached this court seeking interim protection as prayed for. Full stop. It is not in dispute that the petitioner has already terminated the pushcart agreement dated 15/6/2024, by letter dated 8/4/2025, and subsequently invoked the arbitration by notice dated 19/5/2025. Full stop. In view of the termination of the said agreement, and prima facie considering that the pushcarts and deep freezers belong to the petitioner, this court is of the view that the respondent ought not to utilize the same for selling products of the petitioner's competitors. Full stop. Accordingly, this court is restrains the respondent from utilizing, dealing with, alienating, transferring or creating third-party rights in respect of the said pushcarts and deep freezers mentioned in Appendix B of the pushcart agreement dated 15/6/2024 for a period of 6 weeks from today. In the meantime, the petitioner is directed to take immediate steps for constitution of the arbitral tribunal in accordance with the terms of the agreement. Let this matter be listed.
Only one indulgence, Your Lordship. Since the ownership of the pushcarts and the freezers are not disputed, I was only praying for appointment of receiver to take in custody because they are not traceable. They're somewhere in Bihar and surrounding areas. It is not traceable. We have given the address. So let there be be a receiver appointed to take custody of the.
But do you have the address and other things of the?
Your Lordship. The address has been mentioned and the service has now been affected. Gunjaria Bazaar, Islampur.
All right. जहाँ ऊपर लिखा है ना, this इसे last line के पहले लिख दो. The petitioner prays for appointment of a receiver. Let so and so be appointed as a receiver to locate, seize and take possession of the 10 pushcarts and 10 deep freezers.
Para 30 of my petition pleads the location.
No? Where is that?
Para 30 at page 10,
Page
internal
30,
page 10.
para 30.
Para 30, Your Lordship.
The local police is directed to assist the receiver in taking possession of the property. Full stop. उसके बाद कर लेना. In the meantime, the petitioner is directed to so and so list the matter on after 4 weeks.
4 weeks.
After 4 weeks.
In the meantime, we will communicate all. I'm deeply obliged.
My
Lordship,
lord,
for the respondents, Your Lordship, I mean, led by Mr. Rohit Banerjee, is in some difficulty today. If Lordship kindly keeps it not today.
my lord, may I just address, my lord? My lord, this is a post-award Section 9 application. In the interregnum, before the learned arbitrator, we have moved an application under Section 17, wherein an interim protection was granted. Since the claim was unsecured, we have traced out certain freehold properties of the respondents. We have moved the Section 17 application. Learned arbitrator, after it was a contested hearing, after hearing was pleased to grant the interim order. To an extent, the 4 properties are concerned. Now, my lord, on 25th of August 2025, the award has been published. Now, award is due to be executable post December 25th, 2025, calculating 90 plus 30 days. So, my Section 9 application is only to the extent of granting, renewing the prayer that has been granted by the learned arbitrator of injunction. I am not seeking for receiver. Let there be an order of injunction which was already subsisting. Now, after passing of the award, the arbitrator was compelled to, because it became functus officio, it was compelled to vacate it. So, my lord, I am just renewing the award. To an extent, only the injunction is concerned. I am not praying for it. I'll try my luck in the execution once I file it.
Your Lordship, if I may point out, Your Lordship, the arbitration was contested, the claims was satisfied, the award was only issued on the basis of costs. Your Lordship, there is no protection that is required as to the claim amount. The claim amount in the statement of claim was in excess of 1 crore. Now it is, Your Lordship, in some lakhs, 17 lakhs, on the basis of cost. There were settlement talks ongoing. We're in the process of filing an application for setting aside. I'm not getting to the merits, Your Lordship. I'm only praying that Your Lordship may kindly keep it not today. Mr. Banerjee, he's in some difficulty today in the first half. If Your Lordship keeps it tomorrow, we will.
As your lordship.
Not today.
Oblige, Your Lordship.
My lord, I beg to appear on behalf of the petitioner. My lord, Mr. Sarvopriya Mukherjee is leading me in the matter. My lord, he's on his legs. Lord, I was humbly beseeching your lordship to take up the matter tomorrow, my lord.
Not today.
Grateful.
Right. We are for the petitioner in the matter, my lord. Section 34 against an MSME award. A deposit made, my lord. We are, my lord, having a stay on the award as of now. Now, my lord, on last occasion, opposition was directed to be filed in regard to the Section 34, my lord. We have not been served as of now.
I'm appearing for the respondent. I am the award holder. But there was an application, initial application for section 32 and 34, 36 and 34, sorry, my lord. So, my lord, with regard to the 36 application, there was only one hearing held and the affidavit was to be filed. My lord, the affidavit is ready. I can file the affidavit and serve here and now, my lord. But this affidavit was brought in from Bombay, which is why the delay, my lord, and certain documents we had to obtain certified copy, which took some time. My lord, may kindly fix the matter for if my learned friends wish to file their any reply to this. Otherwise, my lord, may fix it for hearing. My lord, the only issue was whether this they have deposited 75% in terms of the award, whether they have to deposit the balance 25%, or whether they by this application they can seek an unconditional stay. I am opposing the prayer for unconditional stay, my lord. So,
May we
reply
be
file
permitted
the-
to file a reply, my lord.
Reply. You want to file a reply?
Yes, my lord. Even on the earlier.
Reply file the respondent. Affidavit of opposition filed by the respondent is taken on record. Learned counsel for the petitioner seeks and is granted 2 weeks time to file his reply to the said affidavit in opposition. List this matter after 4 weeks.
And my lord, the interim order be extended, my lord. It is up to 30th of November. 15th of September, if your lordship sees.
And my lord will only record that I am opposing this prayer, but my lord will pass according orders.
Interim order granted earlier extended further for a period of 6 weeks.
Grateful. 6 weeks from today, my lord.
6 weeks from
Great.
Oh, oh.
Yes.
Call the matter. Okay, matter. Call it. 10. My lord, although this matter, I am the applicant in the section 34. Although this matter is appearing as new motion, directions are complete and I am ready to proceed with the 34. Also in connected, the reason why is appearing as new motion is, my lord, in GA has been filed, GA2. My lord, in the 34 application, asking for, my lord, this encashment of bank guarantee in lieu of a substitute bank guarantee. I will take exactly 4 to 5 minutes to address on that first, and I am also agreeable to proceed with my section 34 application. Will you first take GA2 and my points with regard to that? Now, my lord, GA2, as you see from the cause title, is under section, my lord, 36(2), my lord, and the, yes, is 36(2) of the Act, and the prayer, I believe, which is being pressed, my lord, is prayer, my lord, A. And they did not really press prayer B, my lord, in the limited time, my lord, which was heard. The reason being, my lord, although the award is for, my lord, 1,64,00,000, and it records, it's without reasons, but yet, my lord, as a precondition for stay, I offered to, my lord, if my name, my lord, kindly see the order which is passed. My lord, the order is page 39. And it was passed way back, my lord, on 15th November 21. My lord, during second wave time. My lord, kindly see, this is an application under 36(2). Petitioner prays for stay of operation. My lord, kindly see the date of the award, 28 January 20. It is submitted on behalf, award is in past in violation, same is, then is important. Further submitted that the award is a non-speaking award and liable to be set aside. However, it is submitted, senior advocate, that the petitioner is willing to secure entire principal amount of 48 lakhs. My lord, entire principal amount. I will tell you what the principal amount is. My lord, let me tell you, indicate the principal amount outstanding bills is for 21 lakhs odd, and the rest of the amount is on idle labor, damages, etc., etc. My lord, your lordship can take it from me, you will, if necessary, cite. Mr. Thakkar appearing on behalf of there is substantial amount of interest, heard the parties in these facts and circumstances and materials before this court. My lord, because the material before the court is only the award. And there is something in the award which learned judge at that point of found that, my lord, which is not sustainable, but says, I am of the view, award is liable to be stayed on giving bank guarantee of 50 lakhs and whatever, and with this GA1 is disposed of in AP. And next page, my lord, is the, as is usually the case, it is, my lord, directions are given in 34 and the matter is, my lord, converted to a commercial case. This is the case. Now, my lord, maybe I am exceeding my time for 5 minutes. Para 10.
Para 10
of this application. My lord, I won't take much of your time because you know nowadays, my lord, there's judgment that in lieu of bank guarantee, these judgments are passed. Of course, it's passed. I am sorry. My lord, kindly see.
Yes.
The applicant submits that the entire genesis of instant proceeding dates back to losses accrued. Note the date.
Yes.
Of 2002-2003.
Yes.
My lord, statement of claim is filed in 2013. And the award is of 2020.
Yes.
My lord, the first question which has to be answered is the question of limitation.
Yes.
And how has the award answered the question of limitation? Whether there is any mention of the question, has it been answered by the, is there any recording? Because as you know, patent illegality now, my lord, appears on the face of the award. And
but depending on when the
yes, I'm not. That's why I said I'm prepared to, my lord, at the stage give entire thing. Now, just one by one. Then kindly see para 11, the grounds why they want this. The applicant states that an award has been secured. However, applicant has been unable to utilize as the final disposal are pending. It is apparent entire economy has been adversely affected by the ongoing pandemic because this application was filed just after the pandemic. Please have a look, Millard. Moreover, the situation is no different. Applicant is unable to meet his expenses or employees. It is stated more so in the course of its ordinary business has availed certain credit facilities. However, owing to the turn of events on account, is finding itself extremely to serve the states it has received. Millard, this is the ground. This is the ground. Please have a look, Millard. The applicant further says it has received. Applicant, that is a partnership firm, registered partnership firm, has received 34 lakhs odd from a firm named Ashok Construction on several dates starting from 2016 to 2000. It is pertinent to mention the firm had sent demand notice on 10th February 2023. Have you found that? So I have to pay. How can I pay? And you see the date when it has been affirmed. Please have a look at page 9.
Yes.
Now you find the date is 24th March 23. It is affirmed by a gentleman named Nutu Sengupta. Do you find it? Nutu Sengupta.
Yes.
Yes, he's a partner. He's got money from Ashok farm. Therefore, a demand has come from Ashok farm and he has to pay. My lord, there is a judgment of Justice Moshmi Bhattacharya in BBM saying that in lieu of this bank guarantee can be encashed, and my lord, you can see this judgment and in lieu of a guarantee, no issues. But in that, my lord, it is recorded, which is the paragraph? 21. Paragraph 21. Where is it? Yes. Subsequent events. Kindly see paragraph 21. Paragraph 21. And please have a look at the question of the subsequent events. My lord, it's somewhere, I'll give you the paragraph that the subsequent events, some event that you are in, and they have given.
Subsequent to the.
Oh, yes, it's paragraph 21 itself. It says, the third line, award holders must show that intervention of events subsequent for a decision as to whether it could be given interim relief in form of undertaking. My lord, they have given the subsequent reason. When they filed the application, my lord, that Ashok, to who had given the money in 34, is now demanding. My lord, fortunately for us, Ashok's demand letter, they have annexed. Will you kindly see Ashok's demand letter, another contractor? Please come, page 44. My lord, just the subject, demand notice for financial assistance granted to you on 10th. Please note we have advanced financial assistance. I say, so a final in the form of interest-free loan, and I am demanding. Have you found it, my lord?
Yes.
This is. Now, my lord, kindly look at the top. Whose email of construction, Ashok Construction is there. So, email of Nutu Sengupta and financial assistance. This is the subsequent event of another contractor. My lord, I leave it to your lordship. So far as, and I've given you the judgment, of course you will grant. But to whom? To whom and on the basis of what material? That's the question. I leave it to your lordship. So you can find any of the application, all applications are filed, are affirmed by Nutu Sengupta. As partner of this firm. Is a firm in existence? Well, internet I have not found over there, but can have. But see at the top, who Ashok Construction is. It's another, same locality. It's another contractor, financial assistance. My lord, what financial assistance, interest-free loan, my lord, given. My lord, I am a PSU. My lord, I've given security. I've given it. My lord, if the law demands, but my duty to point out so far as this application is concerned. If you want me to address, but usually this order was passed, my lord, and the both are to be heard, I am ready to proceed with my 34 also.
Proceed with 34.
Can I proceed with 34? Yes.
Yes, my lord. This also I will answer and 34 also together.
Now, my lord, please take the 34 application.
Yes. Yes.
My lord, gist of the matter, your lordship has been able to understand.
Little bit.
I will give you, my lord, a side. My lord, you know, we manufacture cables, and an order was placed for supply of cable drums. My lord, your lordship, and it's a sawmill. It's a name of this Joy Shantoshima sawmill. So your lordship may ask, what are cable drums? My lord, I can show you a picture. My lord, these are these wooden roll type of things. My lord, on which, my lord, cables are there. So the empty drums were apparently, my lord, being supplied by them. This is the case, right?
Yes.
Now, my lord, you want to see a picture? I can give you a picture.
I understand.
Yes.
I can visualize.
But empty. It's just like this.
Yes, I can visualize.
Yes, my lord. Now, my lord, I have shown from their averment in the 36(2) that the transaction is of 2002 and 2003. Now, my lord, as far as I know, my lord, the there is no supply made, my lord, after, my lord, 2003. There is no supply made. Now, my lord, as far as I know, my lord, unless there is a acknowledgement of liability, my lord, limitation, it gives a fresh lease of limitation if it is already expired. My lord, under section 18 or whatever it is, fresh lease of limitation begins. Now, my lord, the claims, and I will read it from the award, because in a 34 court doesn't act as a court of appeal. It looks at the award and whether it is. And if there is no reason in the award, your lordship will not supplement or supplant the reason, my lord, and at the highest, if request, you feel that, my lord, this is without reasons, it will be set aside, but the claim will not disappear. It will, again, a fresh one will start. My lord, if parties agree, new arbitrator, but being a government organization, may not agree. So the recourse is again a section 11, because the claim doesn't. So one has to test it if there are no reasons. My lord, this is the proposition of law. If you want, I can give you the proposition of law with cases, and please see the award. Therefore, my lord, I go by the award. My lord.
See the award.
Yes. My lord. Page 33. It says, by an order dated 20th July 2017, myself was appointed as arbitrator. Before my appointment, was pleased to appoint Mr. Kunal Rai, the deputy manager, as sole arbitrator. Have you found that?
Yes, sir.
Mela, let me tell you, the statement of claim was filed in 2013. That is spelled out from there. Before another arbitrator, 3 arbitrators were changed. And ultimately, since your lordship, may just, I won't waste much of your time, but 46, if you see once.
Yes.
3rd July, it says, parties represent mandate of erstwhile has been terminated. New arbitrator who has entered appearance says arbitrator should endeavor to conclude reference within 6 months of completion of pleadings. My lord, at that point of time, the law was your managing director, my employee, my lord, all these could be, people could have been appointed. My lord, kindly see the order of appointment of 47. Thrice arbitrators have been changed, and in 2017, they say order is passed. Depart. Replacement because inability. Present arbitrator, Mr. Shudip Sengupta, was appointed on 29th. Learned counsel for the submits. Not a single sitting has been held. It cannot be tolerated. Of Shudip Sengupta is terminated, and retired judge is appointed at such and such. Milord, and Milord will be entitled to file. Milord,
নন্দিনী ফোন করছে, একবার নন্দিনীকে ফোন করুন তো।
what's happening? Switch off. The client. And says 49.
Yes, another arbitrator was appointed.
Another arbitrator was appointed.
Yes.
And later on, the extension was granted in 2049 to this learned arbitrator.
Yes.
And that point of time, 29A, there was no limit for 1 year, etc., etc.
Right.
And you will find on 2019, the mandate was further extended,
31st of
and ultimately in
2020.
January 2020, just before the pandemic, onset of the pandemic, award was passed, and the application in 34 was filed in June 2020 in the midst of pandemic. in the midst of pandemic. So it's with it. My lord, will you come back to the award once more?
Yes.
Yes. By an order dated, it is noted that my appointment was pleased to appoint Kunal Rai to adjudicate. Express his desire not to. Then, my lord, may I see what is recorded in the award? Claimant, being a partnership firm duly incorporated under the provisions consisting of two partners, namely Mr. Nutu Sengupta, Shondha Sengupta, were carrying on business. Respondent, being a PSU and the government, were involved in the manufacture of supplying cable wire various sides. They floated a tender notice wherein claimant was successful in bidding and eventually various purchase orders were issued by the respondent from time to time by the claimant. Let me tell you, if you see the statement of claim, which is not referred anywhere, there were 3 such tenders issued, but irrelevant at the moment because you look at the award and see. My lord, kindly see, it is that paragraph lex. It is the case of the claimant. Claimant had diligently been carrying out and raised bills against works done to the respondent for payment. The claimant also reminded for release of payment per contract, despite repeated assurance. Respondent paid no heed to clear outstanding in contravention of the payment terms. My lord, remember what is the 2002-2023? My lord, has it then kindly see. Yes. There is a defense. Goods which were supplied were of inferior quality, broken or in damaged condition. Annexure F and K, they have been referred to. My lord, again irrelevant because there is a finding, my lord, that the arbitrator has considered this and rejected my counterclaim. So I can't, my lord, in a section 34, probably that part, your lordship will not interfere. My lord, that's my, don't take it as a concession, but I feel, my lord, that is the correct position of law. But kindly see, my lord, in the middle, from the facts and facts of the case, it is apparent that the respondent has alleged goods were defective and intimation has been made to the authorized of the agent of the claimant. Then, my lord, kindly see. But I find no document proof of such statement. Already, my lord, recorded. F and, my lord, kindly see the previous page. My lord, if your lordship, one by one, previous page is recorded F and K. And yet says, I find no, my lord, that's a question of perversity, which I will, this is not my main point. Moreover, respondent in terms of also did not impose any penalty on account of ground rent. They were entitled to do so in terms of the console. So you may have said it's bad quality, my lord, which whatever the terms of the conditions, but you did not raise penalty. So you can't raise. This is one. Thus, considering all document and statement and deposition, it would be difficult to believe that goods were defective, rejection or such rejection. I am not going to believe that rejection letters. With pausing, this is a classic case, my lord, of non-speaking award prior to in the 1940 Act. After considering all the statements, pleadings, I award such and such. A classic case. Anyway, that's not my main point, as I said. The case of the claimant is that documents, again says documents, is an afterthought and respondent tried to mislead to deprive. That's the case. Very well. This arbitration has directed to extent, be it mentioned, please have note, statement of claim was filed in 2013. My lord, transaction of 2000, I told you, my lord, 2002-3. Anyway, their application also says so. And respondent filed written statement 2017. I have perused such documents, decide the matter on the following issues. It is to be noted, under general terms of the tender notice, there is specific provision for termination of contract if deviates or continues, respondent will by notice determine the contract. Despite existence of such clause, the respondent never chose to enforce. On the contrary, issued fresh purchase order, which implies respondent was all along satisfied. This is the melod that because I issued fresh orders, the previous which I did not pay, this is and I did not terminate your contract, the main contract, though this is basically this is the reasoning. But more principally, kindly see, respondent has bought the reliefs is principal amount of 21 lakhs. So this is the supposedly unpaid invoices, principal amount. Please make a note, Milord. This is the statement of claim. Then idle labor, please have a note. Please mark it. Milord, what is the period, if I may ask to myself? It is 2004 to 2006, claiming 31 lakhs. I will come 31 lakhs, 2004 to 2006. Then wastage of raw material due to suspension of work whimsically changed in the work order to the tune of 8 lakhs 43. Milord, all prior, Milord, to last supply made in 2023. Then kindly see, Milord, office site expenses due to retention without providing any work order to the tune of 60,000. Now, Milord, loss of profit is there, blocked capital due to, and Milord, security deposit of 40,000. That has to be, Milord, if it is, I'm retained it for some reason, Milord, if it is payable, if the amount of this, Milord, 21 lakhs, you feel that it is payable, Milord, 40,000 as security deposit has to be refunded. Milord, Milord, I here and now, Milord, I concede it's a question of security deposit. If there is no contract, unless I succeed on my claim for, Milord, counterclaim. Now, Milord, please look at the issues. Is the arbitration proceeding initiated maintainable in law as well as in fact? Milord, if it is barred by limitation, which has been noted and discussed, which I will show you, Milord, then says, is the claimant entitled to award of 76 lakhs? How 76 lakhs? Because, Milord, 21 lakhs plus, Milord, all those damages of block capital, etc., etc., for the period 2002 to 2006. Then, Milord, in this, whether there were any rejection letters issued regarding quality, and is there violation by any regarding such rejection? I don't know what sort of an issue is this, but anyway, in the 7th meeting, directed to file affidavit. Client filed its affidavit. My lord, straight away, please come to issue number 1. Yes. My lord, the issue raised by the respondent being the arbitration proceeding is whether it is entered or not. To decide this issue, I have to consider the primary issue. My lord, please note this. Raised in its additional statement of defense was with regard to the claim being barred by limitation. My lord, has your lordship, my lord, a specific issue raised. And secondly, about, my lord, the jurisdiction to entertain, since the question of being barred is a mixed question, the same can only be looking at the evidence led by the parties. So what is the finding of the learned judge, learned arbitrator on the question of limitation? Let's look at it. My lord, it says, question regarding arbitrarity does not hold good in the sense from a perusal of the side, since GTCT clause, there is a valid arbitration raised. Furthermore, was never challenged the existence embodied. As such, there cannot be single reference in the arbitration. I have carefully perused all transactions as well as letter of reference. Mr. Kunal Rai is right. I also found during reference made a composite claim on account of non-payment arising pertaining to the different tender documents. Since agreement contained arbitration clause giving etc. Question of bifurcation, there having several tenders, content could not arise. Therefore, this, where is the decision on limitation? First point. My lord, my point will be section 31(3). Reasons must be given. Question of limitation being more fundamental to the whole thing, a decision was warranted in the facts of the case, particularly when the whole transaction is of 2002, 2003. There is no decision. The main, and the learned arbitrator says, my lord, please have a look back, that the main primary issue is it's barred by limitation. My lord, have you seen page 38, issue under issue number 1? My lord, yes. Then, my lord, please come to issue number 3 and 4. These issues were interlinked, were taken together, delivery, and also whether there were any rejection letters issued regarding quality of goods. Now, my lord, learned is going to the claims, my lord, different claims. My lord, straight away, page 40. I find respondent have never raised issue that the goods were not supplied within time or there was any shortfall in quantity. My lord, have I asked for quantity? I said quality. The time specified in the purchase order as well as in clause 6 stipulates payment within time and such. Now, my lord, a little below. Now, my lord, please have a look at this, please. Now, looking at the date of the first bill, which was issued, my lord, please note the date, 2000, amounting to 2,26,000. And the first payment made in 2000 shows payment was not within the stipulated period. Then a little below, it is also apparent cross-examination bills were acknowledged by affixing. I have acknowledged in 2000. So what? Yes. My lord, though witness could not identify or could not ascertain, I am of the belief bills were indeed received by the respondent. I am also saying bills were received. Who is disputing? Then, my lord, therefore, I find a clear violation that since never made payment within time. Therefore, my lord, kindly see, my lord. I mean, there's a issue is decided in favor of the claimant. My lord, issue 4, my lord, if you feel being a government concern, unpaid bills, my lord, is there. My lord, your lordship will, I mean, I'm prepared, but unfortunately, the law says the section 34 court is not the arbitrator. Kindly see issue 4, rejection letters. Question is violation of the on the contrary, I find claimant in terms of the having delivered within time according to the specific raise their bills. Now dealing with 2 and 5 of 76 lakhs odd. My lord, total claim, remember, my lord, 76. Let's see one by one. First, my lord, unpaid bills. Amount due payable. To decide this, I again place reliance on uncontroverted document being the salary bill and the payments made by respondent. My lord, getting confused with unpaid and salary bill. I find that the bills amounting to 49 lakh, total payment made by 28 lakh, respondent has not controverted any amount in excess being paid. Therefore, by deducting, I find that, my lord, this is on account of 21,1451 unpaid bills. My lord, this is the finding. My lord, without going into question of limitation, my lord, without saying whether I have acknowledged the entire, my lord, 21, my lord, have I, my lord, made this is the finding on the unpaid bills. My lord, has your lordship found this, my lord?
Yes.
Then, my lord, I will go to suddenly at page 11. My lord, stopping here for a moment, with regard to II to V. Now, this is not any issue. Now, my lord, what is II to V? My lord, IV? Kindly come back to the, my lord, what is stated in the award. Straight away, my lord, kindly come to page 36. My lord, will you please come to 36?
Yes.
II. My lord, II is for idle labor from 2004 to 2006. Have you found that, my lord? 31 lakhs at page, my lord, 36, II.
Yes.
Then, my lord, III is wastage duty suspension. My lord, 8,43,000. My lord, period is not mentioned, right? My lord, and my lord, IV is also retention due to retention without providing work order. So I did not provide any work order in 2003 or 2004. This is what that and V, sorry, reimbursement of additional expenses to the tune of 58 lakhs. Now, my lord, let's see how this has been dealt. My lord, may I?
Yes, yes.
I'm sorry, I'm taking a little, but award has to be only taken, looked into. That's what I feel, my lord. 42. With regard, I'll give you, my lord, a 3-page note also. Unfortunately, they briefed me. Yeah, I told them to draft, and in any 34, the first thing is just give a 3-page note so that and give a reply on basis your lordship will pass. With regard to serial number I to V, the same were taken together since they are similar nature pertaining to cost of Mela, kindly see the period. Have you seen the period, Mela?
Yes.
Mela, 2004, wastage suspense, off-site, reimbursement, etc. My lord, it is all for this period. Has your lordship found, Mela? 2006.
Yes.
To prove claim has relied on third party, which was strongly objected, etc. I peruse such documents, annex. I find such documents are third party documents. Now, in support of, I find that the claimant has alleged. My lord, kindly look at this, the period.
Yes.
Due to non-receipt of such and such, I do not find any acknowledgement with regard to the receipt of such letter or any fresh work order being issued on or after November 2006. Admission. There is no work order after November 2006. Have you found that, madam?
Yes.
Yes. But the respondent was still willing to issue, and the claimant on kept its establishment ready to make supply of goods. So, my lord, which is the period 2004 to 2006. Then, my lord, since document in the form of register, I cannot quantify in the absence of evidence. Now, my lord, there is the latest judgment of Justice Dipankar Datta saying, hey, every damage has to be now proved. That's irrelevant. Here, the question, fundamental, kindly see, the claimant has also not relied on other witness to prove. I cannot ascertain whether such laborers were employed during had actually been deployed. It is apparent being works contractor regularly informed Cabledram would have minimum resources in the chief that he was solely respondent to for the issuance. He was not involved with any other side. Thus, it is true, claimant had incurred expenses. Also, I find there was a promise on that fresh work order was issued, and for such, according to me, has parties could not adduce evidence to prove or disprove the claim. How will I disprove? My lord, I am prima facie, must be compensated for damages for which period, my lord? 2024, when no work order was. Thus, my lord, just 12 lakhs. My lord, classic case of non-application of mind, no reason. Learned, I give you a judgment. A judge says, I feel, why not 13 lakhs, my lord? Why not 11 lakhs? Why not, my lord, entire claim? Because learned arbitrator is feeling, my lord, perversity, absolutely. Then, my lord, the claimant has further claim on account of blocked capital, the blockage. Traditional claims, you know, my lord, being in doing some these municipality arbitrations, you are aware of all this. It will happen. It will go on happening because our country is like that. So we cannot. And people show Hudson. Some English authority once said something. Fundamental is our fault is in our system. Then I find that serial VII, such claim has been made of 4,93,000. Look at this, Millard. So you have made, that is probably loss of profit or blockage of capital. It is beyond doubt that there has been delay in making the capital investment. So claim of claimant is justified to some extent. Now, Millard, next says, accordingly is entitled to 2 lakh, 50% of claimed amount. No, it should be 55, I think, or maybe 60. Lordship has plays cricket. Otherwise, that umpire, how's that? 50-50. That biscuit admin. Now, furthermore, the claimant has, in one matter, since your lordship, just 1 minute digressing, I will just, my lord, I found, I was appearing again for a statutory authority. There was a site, which I find both parties are at fault. So I will give 60% and 40%. So as contributory negligence. I mean, tort. I know contributory negligence in contract. I mean, I have not heard about contributory, but may not arbitrator. So I had to, it's an old matter, I had to defend such a thing. So who will explain tort and contributory negligence? Anyway, I'm sorry for digressing. Furthermore, the claimant has claimed rupees 40,000 on account. This is security deposit. My lord, if you are against me on the question of counterclaim, which has been found, I will show you counterclaim. This should be should be given. The security deposit. I cannot hold on to the security deposit. Your lordship may take it as a concession if there is a proper adjudication of my rejection of my counterclaim. And there is none, because I have shown you, I have given documents, since says there is no document. I find there has been no, please look at this. I find there has been no termination at any stage. Question of forfeiture doesn't arise. Who is terminated? Is security deposit, if I have a counterclaim, I will not return. Simple as that. The further claim, this one also. So interest, my lord, kindly see, it is being claimed from 1/3/2004. My lord, it shows that my lord destroys their case. My lord, till actual payment thereof. And then a little below, now section 334 of civil proceedings, power of court. My lord, we are all judges, but one day when we retire, then 34 is power to court. Doesn't give power to arbitrator. 34. So, my lord, then it is to be noted the subject contractor does not specify any rate of interest. To apply principles, I said should be entitled to get interest by nationalized bank. I give 9% to be compounded yearly from 2004. my lord, compound at least 1 and why 9%? I mean, total, I mean, and 2004.
Yes.
My lord, claimant has also cost of arbitration. Say, I think claimant is justified to substantial amount direct. I will not say anything. Then says 7% from date of publication. This is the award. Do I cite the judgment now or tomorrow? I can give you, but my lord, this is the law. Now, my lord, now I can give you first judgments, starting judgments. My lord, is section 34. This is what is stated by the mind of the arbitrator. You are not a court of appeal, but at least you are neither a rubber stamp, nothing side. You are not a court of appeal. You cannot appreciate or reappreciate evidence. So you look at the award. This is the finding. If you feel there are some documents, because I specifically, I settled the matter, my lord, I specifically, my lord, did not annex anything, because all that the section 34 court will see is a reading from the award. If there is a contrary clause that this is not payable, you can refer to the equality. That's what I feel, my lord, is my understanding of the law. So, my lord, I specifically did not annex. My lord, this is no award. A main vital thing of is not discussed. So, my lord, what should the section 34 court, if you are with me on this, do, my lord? Now, my lord, the judgments, lordship sitting with Justice Bakru, I will give them. I found out. Now, severance is possible. Severance is possible, right, my lord? But, for example, I'm telling you, if you find that for unpaid bills, 21 lakhs odd, this is a given, my lord, you can give this and the rest of it, I mean, for damages, etc., on its face of 2004, and is claiming interest from that day of 2004. I mean, these are not payable. Then, my lord, regarding my counterclaim, learned judge, I have annexed certain documents, not discussed. It first says there is no document annexed, and notes their submission, it is, so there is no discussion on the counterclaim as to why I did not pay for such a long time. Why I did not pay for nothing, no counterclaim. But if your lordship feels, no, there is something by the side, your lordship is at liberty, my lord, ultimately you are not sitting in appeal. But I feel, my lord, so what should the court do? My lord, my humble submission, on the basis of the damage claim at least, whether a new reference will start or not, I mean, it's of 2004 and 2006, this block capital damages. That you should not allow also. Regarding whether the aspect, whether it is barred by limitation, 21 lakhs or site, my lord, or the site, my lord, I feel, my lord, that if there are no reasons of limitation given, the matter, my lord, it is possible under, my lord, that lordship is possible under what 34.4, na? 34.4 of the Act. Now, my lordship, remember the judgment of Justice Sanjeev Khan, presided by Justice Sanjeev Khan. But that, apart from that, I will give, there is a difference, my lord, whether, my lord, on the question whether a section 34 court can supplement or supplant the reason of an arbitrator. My lord, a section 34 court, I will first give you an unreported judgment, my lord, of Justice presided Justice Sanjeev Banerjee and Justice Kaushik Chandra of our court. My lord, the arbitrator cannot supplement or supplant reason. But if there is a finding, certainly, and my lord, the finding is a little hazy.
Yes.
Justice Sanjeev Khanna and also Justice Rishikesh Mukherjee's judgment, that one, the other one. Yeah, they say that it's possible. There's a distinction between finding and reason. There must be something. Now, Millard, may I, on this point at least, I've shown you the award. I'm sorry that I read the award, and that is.
No, you have to read the award.
That's Millard, please. And I will give you a short note, Millard. I'm sorry I'm not ready with the short note.
The award is the only thing which I need to say.
I also thought, Millard, and now you are aware, Millard, of section 34(2) capital A. Millard, it's just have a look, Millard. It is argument which is developing, but it's not fully developed. Millard, in some courts are 24 capital A.
Yes.
After amendment, manner patently illegal. Have you found this, Millard? On the face of the award. Have you found, Millard? Is it mentioned somewhere? Millard, 2 capital A.
2 capital A, yes.
Yes. Millard, on the face of the award.
Yes.
Millard, that is patent illegality. Millard, like perversity, patent illegality, that is absolute root of the matter. You must look at the award and see whether it's patent. Unless, of course, it is shocking the conscience. Millard, in fact, in one of your matters where you appeared, I find, shocking the conscience of the court is that, as is customary, we check up the orders where your lordship. So I said, check up, and then we found a number of judgments where your lordship appeared as a counsel, some of them not interfered with. Then I found the latest one was Justice sitting with Justice Bakru. And in one matter, I found Mr. Uttam Dutt had appeared as your senior.
Yeah, that's
right. So I said, that is, well, I'm sorry, but these are things I asked my junior anchor. May I read this judgment if you don't mind? Yes. My lord, incidentally, I will not name the arbitrator who was in that matter, Justice Ashok Kumar Ganguly. That was set aside. My lord, see, my lord, first page. The award runs into 17 pages. Contract between involved a Chinese party ensuring Burnpur. Respondent was to supply components entitled to such and such. My lord, there is no dispute. Supplies were affected by Turbo and some payments were also made. However, it appears Turbo was failed to function, treated as having. Arbitration having been instituted for proper. Yes. Respondent pursued its claim for price of goods supplied. The principal contention was that irrespective of whether turbo blower was commissioned, was entitled to, right, the principal defense in course of arbitration was that till the liability was decided, claim could not be appropriately adjudicated. Malad, next is the side. Over 17 pages, well, this is not 17, but nevertheless, it's substantial. There is an arbitral award. The first 16 cover the dispute whether the respondent could have independently pursued against, divorce the claim lodged against the Chinese party. The arbitral tribunal found respondent's claim did not have to await outcome. However, upon arriving at such founding, the heads of claim were set out entirety, allowed without so much a sentence on any head of claim. It does not appear on a reading of the counter statement filed before that any was admitted. There is no recording in the award has considered. Indeed, no recording that I have admitted, even here. Indeed, counter filed shows a robust challenge. In light of the denial of every individual head, it was incumbent of the arbitral tribunal to adjudicate upon entitlement without and thereupon ascertaining the quantum thereof. The arbitral is singularly lacking in such regard. There is no whisper as to why was found to be entitled to any head of claim, far less any hint of discussion of quantum. Claims were not adjudicated, not the quanta assessed. The act obliges arbitral tribunal, this is the to furnish reasons. My lord, this is the important bit. In support and the heads succeed. It is also opposed to public policy, which would be the outcome, will never reveal the mind was applied to matters in issue to arrive at a cogent finding. The court of her acted wholly without jurisdiction in taking upon the burden of adjudicating the dispute. This is exactly what an arbitration agreement forbids the court to do. The adjudication has to be undertaken and completed in course of arbitral reference, and the court on receipt of challenge exercises superficial interference limited upon a court in receipt discovering has not furnished any, Malad, have you found that portion?
Yes, yes.
Any adequate reason. It is not for to supply the reasons in support or to supplement the reason, and ought to have taken in the award itself. I, my lord, add it with a little bit of caution to this judgment. You cannot supplement, but if there are reasons and there are hazy reasons, you can, my lord, do this. The court misdirected in treating as a court of a civil suit, the extent and quality of jurisdiction completely different. The judgment and order set aside is set aside. Parties are left to have dispute by reference. Parties have agreed. If I agree, you will side. If I don't agree, you will not throw him out. Then, my lord, the recourse in accordance with law, as my lord in this noted that in accord, which is basically file a section, because the arbitration thing doesn't disappear. My lord, it's a fault, with great respect, of an arbitrator if he doesn't give reasons. My lord, this thing, my lord, is also, may I cite one Supreme Court judgment?
Yes.
My lord. My lord, it is reported in 2022, 3 SCC. My lord,
Paragraph?
my lord, kindly see. My lord, kindly see para 37, probably. Look, I haven't had they briefed me yesterday. I told my juniors, look up this point, look up that point. So, my lord, para 30, my lord, let's start with, my lord, 34, my lord, if your lordship.
Yes.
Yes, 34. In Diana, I think it's Justice Ramana's judgment, if I'm not mistaken, my lord. It was a case, there was no inquiry under 34, was held that the legislative intent is to make award enforceable after giving opportunity to undo the curable. It was not a case of patent illegality. This is a case of patent illegality. But deficiency, my lord, due to lack of reasoning. In the very same case, it was clearly held there was complete perversity in the reason and the ground of the act. My lord, if it is perverse, there is no reason, then my lord side. In Somdat is also a case where no reasons were given for the finding already in it. Course held that in view, High Court ought to have given an opportunity to give reasons. My lord, this is side. The aforesaid case cited by the learned is distinguishable, etc., when it is the specific case of the respondent that there is no finding at all. My lord, this is where I am on. Whether the contract remission is not permissible, in our view, 34 can be resorted to fill in the gaps in the reasoning. There is a difference in finding and reason. My lord, this is what I have been. My lord, my lord, my lord, this is what I wanted to say, my lord.
Yes.
Is there any finding on limitation? It stares at you. My lord, regarding the urgent, other traditional, which again that Sayong thing would come. My lord, you want some judgments. I must confess.
Sayang and all too.
My lord, I'll have to give. Just can I complete? I mean, give some judgments if you don't mind.
No, absolutely give it.
And note ta kobe debe? Huh? Hey? Approval. Oh, I said an opening submission should be handed over, whatever I argued to your lordship.
And that is, you can always give a 2-pager, 3-pager.
Yes, but
after the-
being a PSU and Cowan said to get approval.
Then forget it, don't give it.
My lord,
You don't need that.
my lord, so when is it convenient for your lordship to keep this no, for the rest of the cases? My lord,
You can do it now. You can
no, my lord, I said, my lord, I just brush up.
conclude the arguments. You give
Conclude
a
the argument.
3-pager with
No,
all
no,
the
no,
relevant
no,
judgments
no,
you
no.
wish.
The arguments I have, the case law and all on
Within a
this.
week. Within a week, you file your written notes with whatever
My
judgment.
lord,
you want.
I can, I will. I've given you the points, my lord, and my lord, and I told you, my lord, what is the scope of 34, and given there is no finding. If there is judgment on 31.3, the 31.3, if there are no reasons, my lord, it is perverse. My lord, that's paragraph what of associated and also followed in Sayong. It is patently illegal. That's the wording. Wording, my lord. And there is no finding. Now, my lord, in the opposition, they have annexed the statement of claim, the side, everything, and said, oh, my lord, I can tell your lordship what they have annexed, but I cannot supplement or anything.
Let them do that.
Then I have to, on that point, I can also give you an answer. But again, my principal point is you only look at the award. My lord.
Yes, Mr. Van.
And regarding 36.2, I've given you what sort of this loan has been given by Ashok Construction.
My lord, I believe Mr. Bose is not going to rely on any other judgments.
Yes,
my
I
lord.
am.
Then, my lord, it would be like halfway. How will I start? My lord? Let him give the judgments and I can come back.
Mr. Banerjee, you
I can start.
You can start. Whatever Mr. Bose wants to give, he will give with his written submissions now.
But
These are the two judgments which he basically
I'll deal with.
Principally. And
Very well.
the rest are all principles of law which you don't need to answer.
My lord, before I take my lord to the judgment, my lord, the 36.2 that my lord he pressed upon, he opposed. My lord, may I just show that my lord, I don't even need to give a reason actually, because this law of arbitration, my lord, it does not say to secure or take it out or not to secure or take it out. This is, my lord, a mechanism which the courts have, my lord, made out, since arbitration is wholly a luxury litigation because it's all commercial. So, my lord, in order to see that, my lord, the money is not stuck and an order of stay is, my lord, obtained and enjoyed for years, this mechanism was taken out where I can secure the amount and, my lord, I can take out the money. So, my lord, they are not prejudiced. So, therefore, my lord, saying that no reason is given, although here the reasons are given, my lord, is neither here nor there because no reasons are required. As long as I, my lord, secure the entire amount.
Argue on the merit
Yes.
of 34.
Now, my lord, if lordship comes to section 34, without even going into section 34, let us understand, my lord, what is the scope of 34. My lord, may I just start with a judgment and then take you, my lord, to the award. My lord, kindly takes this judgment, which in modern times, my lord, sets the section 34 principles, which he said about, but he purposefully did not deal with or, my lord, show. This is, my lord, 2019 20 SCC, page 1. This is Diana. And, my lord, this is the judgment which requires to be looked into, which is only referred in that judgment, but he did not show. My lord, kindly comes to a few paragraphs which are only required to be looked into. What is the principle?
The paragraph numbers.
Yes, my lord. And what is the distinction? Lordship will kindly come to, my lord. Sorry, one moment. Paragraph 34. If I may read, my lord.
What are the other paragraph you're relying on?
34, 35, 36, 37. That is all, my lord. 4 paragraphs I want to show. But kindly takes 34. The scope is very limited. The mandate under section 31(3) of the Arbitration Act is to have reasoning which is intelligible and adequate, and which can in appropriate cases be even implied by the courts from a fair reading of the award. And my lord will kindly refer this, underline this, and documents referred to thereunder, if the need be. This is why the records are called for. The aforesaid provision does not require an elaborate judgment to be passed by the arbitrators having regard to the speedy resolution of the dispute. I did not, my lord, write word to word what is being filed before me. Yes. Now, my lord, when we consider the requirement of a reasoned order, 3 characteristics of a reasoned order can be fathomed. They are proper, intelligible, and adequate. That is all lordship is to look into. If the reasonings in the order are improper, they reveal a flaw in the decision-making process. If the challenge to an award is based on impropriety or perversity in the reasoning, then it can be challenged strictly on the grounds provided under Section 34 of the Arbitration Act. If the challenge to an award is based on the ground that the same is unintelligible, the same would be equivalent of providing no reasons at all. Coming to the last aspect concerning the challenge on adequacy of reasons, the court, while exercising jurisdiction under Section 34, has to adjudicate the validity of such an award based on the degree of particularity of reasoning required, having regard to the nature of issues falling for consideration. Therefore, my lord is to consider to the extent it is required. It is not, my lord, a straitjacket formula that one has to write this only. Then, my lord, the degree of particularity cannot be stated in a precise manner. As I said, my lord, no straitjacket formula, as the same would depend on the complicity of the issue. Even if the court comes to the conclusion that there were gaps in the reasoning for the conclusion reached by the tribunal, the court needs to have regard to the documents submitted by the parties, which Mr. Bose did not show once to my lord, the records. The documents submitted by the parties and the contentions raised before the tribunal, so that the awards with inadequate reasons are not set aside in casual and cavalier manner. So therefore, my lord, if the reason is not there and the documents are there, it is presumed, just like a court, that it is been considered by the court or a tribunal. So, my lord, on that basis, blindfoldedly, my lord, an award would not be set aside. Kindly seize, my lord. On the other hand, ordinarily unintelligible awards are to be set aside, subject to party autonomy to do away with the reasons with the reasoned award. Therefore, the courts are required to be careful while distinguishing between inadequacy of reasons in an award and unintelligible awards. At this juncture, it must be noted that the legislative intention of providing Section 34(4) in the Arbitration Act was to make the award enforceable after giving an opportunity to the tribunal to undo the curable defects. This provision cannot be brushed aside, and the High Court could not have proceeded further to determine issue on merits. In case of absence of reasoning, the utility has been provided under Section 34(4) of the Arbitration Act to cure such defects. Where there is complete perversity in the reasoning, then only it can be challenged under the provisions of Section 34 of the Arbitration Act. The power vested under the provisions under Section 34(4) of the Arbitration Act to cure defects can be utilized in cases where the arbitral award does not provide any reasoning, or if the award has some gap in the reasoning or otherwise, and that can be cured so as to provide a challenge based on the aforesaid curable defects under Section 34 of the Arbitration Act. However, in this case, such remand to the tribunal would not be beneficial, and we are not on that. So therefore, my lord, what are the three principles? One is that, my lord, lordship has to see whether it is proper, intelligible, and adequate. And secondly, my lord, by the records and the reasoning, or even if there is no reasoning, there are records or documents to prove the same. Whether, my lord, there can be any interference at all required or not. Because if the records are there, it is taken that the tribunal has considered it. May not have, my lord, word to word, my lord, reproduced it in the award. It is never so. Now, my lord, I understand. In his fairness, he said that he has been briefed last night. He had taken the point of limitation. He has taken the point, my lord, that, my lord, it is perverse on the face of it. Kindly takes, my lord, the point of limitation, why it is proper, and so why the documents required was to be filed in my lord, the section in the opposition. The opposition is all about the court records or the tribunal records, which lordship, I said, my lord, is only what is required in a section 34. My lord kindly takes the pages, my lord, which the arbitrator has considered. And, my lord, there has been extensive cross-examination on this. Bolo, limitation page gulo bolo. My lord kindly comes to page 106. I'll show from the initial time. According to Mr. Bose, my lord, 2004 is the cause of action. So, my lord, we take it that 2004, if it is the cause of action, my lord.
Which page?
106, my lord, of volume 1. This was marked as, my lord, kindly will see at the top, exhibit number C37. Kindly sees the date, 4/12/2003. Kindly note the following revision in quantities in various sizes as below. This revised schedule is superstition of the earlier. So therefore, my lord, the contract is on acknowledgement from their end. Now, my lord, kindly comes to the next document. 114. Page 114, lordship kindly comes from. Now, my lord, kindly sees. This is again, my lord, exhibit C43, 22/7/2006, within the period of limitation acknowledgement. You are well aware that there was no production since the last couple of years. After a lot of persuasion, we at all levels, our high-level meeting held is scheduled early next week. We have to offer the production rates. Appreciating situation, we would request to offer you most competitive. Now, my lord, this is also issued by them in 2006. Now, my lord, next letter. Bolo. Yes. 116, lordship kindly comes. This is, my lord, their letter issued on 21st of February 2009, C45, exhibit 45. Kindly arrange to furnish bill-wise details of the amount receivable by your organization from Hindustan such and such under the following heads. Acknowledgement, continuing. These should have been shown. Then, my lord, kindly sees my lord, their letter of admission, my lord, at page 121 again. C47, exhibit 47, dated, my lord, 7th of October 2010. Kindly sees the admission. May kindly note that outstanding balance of your concern as per our books account is under 15 lakhs and odd, and another, my lord, 40,000. So this is, my lord, that they acknowledge that they need to pay to me. Now the disputes arose, it was referred thereafter soon on, my lord, 2nd of September 2013. That's at page 124. That's within the period of limitation. It has been referred. Kindly sees this is the first reference which was made, which is C49. Exhibit C49.
Yes.
This, my lord, kindly sees is the first reference made to them. The next letter, my lord, kindly comes to page 129, which is just thereafter, 26/9/2013, whereby, my lord, they have been, my lord, asked that disputes and differences have arose, and, my lord, under the general terms of conditions to make an appointment, since, my lord, then the law had not changed by then. And, my lord, the details of our claim is been referred to there. Now, my lord, kindly comes to page 132, which is exhibit 51, which is their appointment itself. So where is the question of limitation? It is all been considered. This cannot be said to be, my lord, something perverse, something, my lord, where the intelligence has not been used, something, my lord, where the records has not been gone into. And this has been exhibited, this has been cross-examined, and this has been proved before, my lord, beyond doubt, that there is no question of limitation per se, my lord, the claim of the claimant is concerned. Now, my lord, the second issue that he raised, that, my lord, their claim has not been considered at all. My lord, their claim was considered. In fact, they have not enclosed, my lord, the evidence. If your lordship calls for the records, lordship will see they have been extensively cross-examined. After cross-examination, since they could not prove, my lord, the claim, the counter-claim that they had filed, therefore it was rejected. So it is, my lord, not in their mouth to say that, my lord, there was no chance given to prove their case, no cross-examination given, and, my lord, that their claim was outrightly rejected. That's not the case. That is exactly why, my lord, I always say, my lord, only the records are required. Call for the records of the arbitrator. This is incorrect on the part of a section 34 petitioner to say.
So you have not filed it with your
But evidence, their evidence I have not filed. I might not file the exhibits that are mine, because, my lord, counter claim is there, my lord, claim, counter claim is there, my lord, petition, they should file it. Voluminous, my lord, evidence was given, my lord, and, my lord, it was considered and cross-examined. It is only that now the advocate on record have changed for them. So, my lord, they might say don't have the records. The arbitrator, my lord, is there. Lordship can call for the records if my statements are wrong. So, my lord, without showing before my lord that, my lord, opportunity was not given, or, my lord, they were not allowed to give, my lord, examination in chief to prove their claim, my lord, how can they come before the court and say that, my lord, the arbitrator has dismissed my counterclaim just like that? And the judgment, my lord, why I read before taking, my lord, to the documents is that, my lord, documents as well as the reasoning. So, my lord, documents would prove for itself that, my lord, the arbitrator has considered it. Now, my lord, apropos this now kindly comes, my lord, to the award. Justice Banerjee's, my lord, judgment shown that is on a different context altogether.
Yes.
My lord, kindly comes to, my lord, the part where, my lord, the reasoning is given. Kindly comes to page 39, issue number 3 and 4. The arbitrator starts with, my lord, he does not start with 1 and 2, but starts with issues number 3 and 4.
No, one he has dealt with. The first issue is one only.
Yes, my lord, kindly comes to the issues first. Let us, my lord, see the issues
He
first
doesn't
at page
start with issue
37.
number 3 and 4. He
Yes,
deals
my lord,
with issue
kindly
number-
comes to page 37 first.
Yes.
The issues. Therefore, my lord, considering the evidence and, my lord, everything, he's, my lord, again reiterates the issues which are there. Is the arbitration proceeding initiated by the claimant is maintainable in law as well as in fact? Is the claimant entitled to an award for such and such? Whether there is a contract between the parties regarding delivery of goods on time as per specification provided in the said contract? Whether there are any rejection of letters issued by the respondent regarding quality of goods? Whether the claimant is entitled to get reliefs as played for? Now, my lord, kindly sees, my lord, there is not a whisper, my lord, in, my lord, the section 34 application that the issues were not in accordance with the parties, my lord, whatever they had given, or the issues were not framed properly. There is not a single whisper in his section 34 application. Nowhere. So therefore, he, my lord, accepts the issues framed are correct and accordingly adjudication done. Now, my lord, kindly sees. Next paragraph. In the 7th sitting dated 8/5/2018, this tribunal directed the parties to file their affidavit of evidence. The claimant partnership firm has filed his affidavit of evidence through its sole witness, Mr. Such and Such, who has been examined. The claimant in its affidavit of evidence has relied on the documents from Exhibit 1 to 6. Mr. Such and Such, present consultant for the respondent company, has deposed on behalf of the respondent, who have been cross-examined. So it was, my lord, the duty of my learned friend's client to produce those records before my lord, before making statements against the arbitrator. So he was cross-examined at length. I have considered all the documents on record and the evidence adduced by both the parties during the proceedings. I think that, my lord, puts an end to everything. Now, my lord, kindly sees. Now I shall deal with the issues as framed. This issue number 1, this issue is raised by the respondent, being the arbitration proceeding initiated by the claimant, is whether maintainable in law as well as in fact or not. To decide this issue, I have to consider the primary issue raised by the respondent in its additional statement of defense was with regard to the claim being barred by limitation. So therefore, my lord, will see, initially they did not raise the point of limitation at all. It was only an opportunity was given to them by the arbitrator that, my lord, they filed an application for additional statement of defense where they have taken, my lord, the question of limitation. So therefore, it can't be said that they were not given opportunity. Then, my lord, secondly, if the arbitral tribunal not having jurisdiction to entertain the instant proceeding between the parties, since the question of claim being barred by limitation is a mixed question of law and fact, and the same can only be proved upon looking into the evidence laid by the parties. So therefore, the evidence was laid which was considered. I have shown letters being marked as exhibit uncontroverted, my lord, from 2003 right up to 2010, which is before my lord also. And they have not contradicted this in their reply, my lord. Kindly take their affidavit in reply that these were not marked as exhibit and proved. So therefore, my lord, how come lordship today, my lord, is not going into evidence? Then lordship cannot, my lord, decide in 34, as has been said by the principals, my lord, that, my lord, it was not looked into when the tribunal itself records that I have looked into the evidence and the facts of the case while deciding limitation. Now, my lord, thirdly, the question regarding maintainability of the arbitration proceeding by referring to Section 7 by the counsel for the respondent does not hold good in the eye of law, since from the bare perusal of the tendered documents, more specifically the GTCT and Clause 9 embodied therein, there is a valid arbitration clause binding between the parties. So therefore, my lord, the question of jurisdiction was raised, that has also been considered. Now, my lord, kindly comes to the next paragraph. I have carefully perused all the transactions between the parties, as well as the letter of reference made by the claimant to the respondent, on the basis of which had agreed to nominate Mr. Such and Such as the arbitrator to arbitrate the disputes between the parties. I also find that during such reference, the claimant has made a composite claim to the respondent on account of non-payment of bills arising out of several purchase orders pertaining to the different tender documents. Since the agreement contained an arbitration clause itself confers exclusive powers under the respondent to nominate and appoint arbitrator, the question of bifurcation of contract and there having several tender documents containing arbitration clause could not have arisen at this point. So the question is dealt with. Thus, I hold that the issue 1 is decided in favor of the claimant, and this arbitration is maintainable in the eyes of law. So he has considered it. Now, my lord, kindly sees 3 and 4. These issues being interlinked are taken up together for the sake of convenience. The aforesaid issues speak about existence of any valid contract between the parties regarding delivery of goods, and also whether there were any rejection letters issued by the respondent regarding the quality of goods. My lord, this is his counterclaim also, because, my lord, it is his case in counterclaim that due to the rejection, my lord, his claim is maintainable. That's his counterclaim. Maybe, my lord, it is not couched in the manner that he wants, but it has been dealt with. Now, my lord, kindly sees. At first, the question of payment being not made within the due time by the respondent is to be considered. Since the purchase order issued by the respondent itself is a contract containing the terms and conditions between the parties regarding payment, delivery, and inspection, I find that the respondent have never raised any issue. So they have conceded to the claim of 21 lakhs. That is why Mr. Bose was saying severance is possible. Pay them 21 lakhs and let them go. Because he knows that his clients have gone there and admitted that part of the claim itself on the first day. So, my lord, if that part of the claim is, my lord, admitted, then, my lord, where is the question of defective goods? If there is no question of defective goods, then there is no question of counterclaim, rightly adjudicated by the arbitrator. He himself said that part, lordship, can severance is possible. Lordship can sever that 21 lakhs, give it to them, my lord. I have nothing much to say about that. And his clients have considered it here. And where is the question of counterclaim then? Now, my lord, kindly sees. I find that the respondent have never raised the issue that the goods were not supplied within time or there was any shortfall in the quantity of the goods. Though it is a specific case of the claimant that there has been a breach on the part of the respondent in making payment to the claimant within the time specified in the contract, the time specified in the purchase order, as well as in clause 6. So every clause has been looked into of the GCCT stipulates that the payments for bills raised or quantity supplied, whichever is later, has to be made within 30 days from the date of the receipt of such goods or bills. It is absolutely apparent from looking, kindly mark, my lord, into the documents and the records of this case that though the bills were raised by the claimant within time, but the payment in respect of such running account bill were not made within the stipulated period. Now looking into the date of the first bill, which is issued on 1/7/2000, amounting to rupees 2 lakhs and odd, and the first payment made through check on 39/2000 amounting to 50,000 clearly shows that the payments was not made within the stipulated period in the contract. It also shows that there was shortfall in the payment of the entire invoices raised by the claimant. So that, my lord, takes us to 2004, then to 6 to 9, where they say that give us, my lord, the invoices again so that we can pay you. It also is apparent from the cross-examination of the respondent's witness. What more is required? Respondent's witness that the bills were acknowledged by the respondent by affixing the stamp of the respondent company. Though the witness has stated he cannot identify the signature of the officials or could not ascertain whether such stamp is genuine or not, but I am of the firm belief that the bills were indeed received by the respondent because that's acknowledged by him. So the entirety of the evidence has been scrutinized by the arbitrator. We cannot, my lord, read awards in, my lord, those portions which, my lord, helps me out in certain way. We have to read the award as a whole. Now, my lord, kindly sees. After this, he comes to a finding. So, my lord, saying that there is no finding given, no reasoning given is an absurd submission made. Kindly sees, my lord. Therefore, I find there is a clear violation of the terms and conditions of the purchase order as well as GTCT of the respondent, since the respondent never made payment within the time as stipulated in the contract. Therefore, issue number 3 is decided in favor of the claimant. Issue number 4 deals with the rejection of letter issued by the respondent regarding quality of goods. This is his counterclaim. Kindly sees, my lord. He says his counterclaim is not dealt with. Supplied by the claimant is decided against the respondent. The question as to whether there is any violation of the contract or any of the parties regarding such rejection is also decided against the respondent, since the respondent committed breach of the contract by not making payment within the stipulated period as stipulated in the contract. Now, my lord, this is, my lord, natural that, my lord, if I accept, my lord, I have not paid, then I cannot have a counter argument saying that the goods were not of quality and was supplied within time. I can't. And that's exactly what the tribunal has held, rejecting, my lord, his counterclaim thereafter. Now, my lord, on the contrary, I find that the claimant in terms of the said contract between the parties have delivered goods within the time according to the specification and have raised their bills and invoices to the respondent. Even upon receipt of such bills and invoices, the respondent has made part payment to the claimant, and not in terms of the purchase order. Now dealing with issues numbers 2 and 5, which deal with entitlement of the claimant to an award of 76 lakhs and odd, along with other ancillary reliefs, amount due against the supply of wooden cable of drums for the sum of 21 lakhs and odd. To decide this issue, I again place reliance. So he goes back to his reasoning, my lord. An uncontroverted document being the salary bill raised and the payments made by the respondent. So the documents are again, my lord, considered by the arbitrator. I find that the bills amounting to 49 lakhs and odd, and the total paid by the respondent is 28 lakhs. The respondent are not controverted any sum in excess of 28 lakhs and has been paid to the claimant. Thus, by deducting the amount, 21 lakhs is odd is due. What more reasoning the tribunal will give? It has to give a comma full stop. It means, my lord, whenever there is a judge award passed by any arbitrator. Then, my lord, kindly comes to Roman 225. With regard to serial numbers 2 to 5, the same are taken up together since they are of similar nature, pertaining to reimbursement on account of cost of idle labor for suspending the works from 6/1/2004 to 31/10/2006, wastage of raw materials due to suspension of work offsite due to retention, any order reimbursement on account of additional expenses incurred for plant, tools and machineries. Now, my lord, very conveniently, my lord, he read a few lines from there and said, how can this be given? Now, my lord, why it can be given is that, again, he should have referred to, at least he has not annexed, I have annexed the documents before the arbitrator. Kindly now, my lord, kindly sees, then I'll read this. Kindly comes to page 109. Volume 1, kindly sees page 109. How I prove my case for damages. There's a promise made by them that they'll give me the work and I should be ready enough to, my lord, serve them or supply them. 109. Kindly comes to page 109, my lord. This is a letter dated 10th of January, my lord, 2006. See, my lord, what they asked from me. You are well aware that there was no production since last couple of years for want of order and advance from Messrs. BSNL. That's their third party, my lord. After a lot of persuasion at all levels, high-level meeting between BSNL, MTNL and HCL officials is scheduled to be held tomorrow morning, where we have to offer the rates of all sizes of PFU cables for your placement of orders. Appreciating the situation and considering the mutual benefit for both of us, you are requested to offer your most competitive rates for the following items. Now, my lord, this is where they ask me to do things for them. Then, my lord, kindly sees, they do not stop here. And this is, my lord, C39, Exhibit 39.
Yes.
Now, my lord, kindly comes to page 114. 22/7/2006. This is just after 6 months. Everything considered. C43, given by them. You are well aware, same thing is quoted, my lord. And now they say, appreciating the situation, we would request you to offer your most competitive rates. So, my lord, they are inducing me to work for them and have everything ready. Now, my lord. So now, my lord, kindly sees next page itself, which is, my lord, 24/7/2006. I have given the rates to them. This has been considered. Apropos this, my lord, now comes back to the award at page 42. He kept me waiting for 2 years. Now, my lord, kindly comes to page 42. When, my lord, we show a portion of the award, we must also relate to the documents, my lord, the exhibits. Kindly comes to page 42.
Yes.
To prove the claim. So I have proved the claim. To prove the claim, the claimant had relied upon third-party document which has been strongly objected to by the respondent. Such document being the attendance register, the salary register, road challans and sale invoice raised by the suppliers. I have perused all such documents. Again, my lord, as the Supreme Court says, documents need to be looked into also. Annexed to the affidavit of evidence of the claimant. And I find that such documents are third-party documents. Now, in support of such contention, the claimant has relied upon certain letters of of the statement of claim. Now, these are the letters. These are the letters of the respondent. They are not of third parties. I find that the claimant has alleged that they have been sitting idle from 6/1/2004, which is exactly what the letter says, that you're waiting for a couple of years. If I may not read it again. Due to non-receipt of any order and incurring expenses on account of idle establishment, idle labor, and also for maintenance. I do not find any acknowledgement on the part of the respondent. In fact, this has gone wrong, my lord, because that letter is from them. So acknowledgement is galore from their end itself. Acknowledgement from the respondent with regard to the receipt of such letter or any fresh work order being issued by the respondent to the claimant on or after November 2006. But the respondent was still willing to issue work orders to the claimant, and the claimant on such assurance had kept the establishment ready to make supply of goods of the respondent. Where is it without a reason? It is apropos the documents which have been marked as exhibit and cross-examined. And my lord, another document I must show, otherwise this would be improper. Kindly sees 107 once, my lord. Apropos their letter of acknowledgement and writing to me, I show them, my lord. My lord kindly sees, my lord, 107.
Yes.
This is my letter 15/1/2005 to them regarding supply of such and such. My lord kindly takes, my lord, the third paragraph. This is also for your further information that during the December 2003 to 2004, last 13 months, due to non-receipt of any order and payment, we are completely idle with our laborers, staff, tools and plants and other establishment which we have arranged to procure to carry out your order. As a result, we are suffering various losses. My lord, this I have proved. Let him show from evidence, my lord, that he has been able to disprove this case of mine. And that, my lord, in his prudence, the arbitrator, my lord, has considered. So it is improper to say, make submissions contrary to the records of the arbitral tribunal. And that's exactly the reasoning given. He's saying, my lord, lot of hue and cry saying that no reasons given. What more reasons will he give? He has dealt with every document filed by the parties. Now, my lord kindly sees, since the documents produced by the claimant in the form of salary register, attendance register, sale invoices, challans are all third-party documents and have been strongly objected, I cannot quantify amount in absence of any evidence. So therefore, my lord, he has not considered the third-party documents. He has only considered the documents inter-party, which was given by him to me and the one that I wrote to them proving my case. Now, my lord kindly sees, the claimant has also not relied on any other witnesses to prove such claim for the sums paid for. I cannot exactly ascertain whether actually such laborers were employed during the period of claimant and actually deployed tools. It is apparent that the claimant, being works contractor regularly involved in the business of manufacturing and supplying wooden cables, would have maintained. Here, my lord, I wouldn't say, my lord, the word would not come because I have. They also acknowledge and they write letters to me to keep, my lord, apropos their demands. The minimum resources required for running his establishment. It has been categorically stated by the claimant during his examination in chief and cross-examination. So I was cross-examined on these issues. He could have demolished my case. He couldn't. Cross-examination that he was solely dependent on the respondent for issuance of a work order during that period and he was not involved in any other contract during such period. Thus, it is true that the claimant had incurred expenses on account of idle labor, idle establishment, and wastage of materials. I find there was a promise. That's exactly the documents. I find there was a promise or assurance on the part of the respondent that fresh work orders would be issued to the claimant, and for such work orders, the claimant must keep its establishment ready. According to me, since both the parties could not adduce evidence to prove or disprove the claim of the claimant with regard to the aforesaid heads, I am of the prima facie opinion that the claimant must be compensated for damages incurred during the period 6/1/2004 to 31/10/2006 when no work orders were issued by the respondent. Thus, I am of the view that under serial numbers 225, the claimant is entitled to a sum of approximately 12 lakh on account of aforesaid loss or damages incurred. Total claim my claim was on that, my lord, close to 44 lakhs. He has only given me only 12 lakhs. And my lord, he has given the reasoning. Now, my lord, this is settled law that, my lord, reasoning, my lord, will not be looked into by the court, my lord. That's not the work of, my lord, in a section 34 application, because it's not a code of appeal. So it is improper to say that, my lord, the documents have not been considered, no chance given to prove his counterclaim, no, my lord, cross-examination, my lord, acts where, my lord, not given them to cross-examine. Everything they have given, 41 lakhs. And, my lord, apropos that, considering the documents, my lord, he has come to, my lord, a lump sum figure of 12 lakhs, which, my lord, according to the prudence of the arbitrator can. That, my lord, even in courts it happens, my lord. Now, my lord, here to say, my lord, Hudson, my lord, recent judgments say Hudson should not be followed. But courts in fact, in Calcutta used to follow Hudson a lot. But, my lord, that's not the issue. In every case, Hudson need not be followed, or not even be followed. If the arbitrator in his prudence, my lord, can consider, there is, my lord, an assurance and a promise. And, my lord, accordingly, I have maintained it. And he has rejected my third-party documents, only relied on inter-party documents to come to a conclusion. That conclusion cannot be questioned, because, my lord, that conclusion is not perverse. Because that conclusion, my lord, is not devoid of evidence. That conclusion is not, my lord, in a manner made where fraud has been committed, or that conclusion is not, my lord, in a manner where one party has been prejudiced by not giving a chance of cross-examination even. Now, my lord, apropos this, thereafter, my lord, what comes is, my lord, the interest part. My lord, interest is the discretion of the arbitrator. Interest, my lord, is the discretion entirely of the arbitrator. Interest cannot be questioned by a court, my lord, unless and until it is something beyond, my lord. If it is 17%, my lord, commercial rate, if he is given, my lord, 58%, I would have understood. And, my lord, whether it has to be simple or, my lord, compound, that also it's the prerogative of the arbitrator. My lord, in a commercial litigation, it is quite natural, considering, my lord, the manner in which section 34s are pending nowadays, except now, my lord, I find every day we have to come ready and do the matter. My lord, it is quite natural that it should be given in compound rate. Because, my lord, hardly 34s are heard. And yesteryears, my lord, lordship, remember, filing a 34 is automatic stay. No stay was required. Now, my lord, here, my lord, even the amount which is been put in, after that, my lord, 34 is never taken up. So, my lord, it is, my lord, the person who is an award holder, my lord, company would come to doldrums. So, my lord, interest is a prerogative of the arbitrator. If it is, my lord, something which is, my lord, apparently, my lord, something, my lord, as I said, 58% or 98%, I could understand. Compound interest, 9%. I think that's very commercial. My lord, I may say that unlike other arbitrators, he has been little commercial. But, my lord, to be commercial, my lord, or to think as a judge even in commercial matters to be commercial and not to have, my lord, a lot of sympathy is, my lord, I think should be what luxury litigation should be looked into. Because, my lord, I don't find villagers doing arbitration proceedings. It is one PSU against whom I am as a singular litigant fighting. So, my lord, obviously it should be looked in a commercial, my lord, manner. I don't think it is improper to look it into a commercial manner. And kindly see, my lord, 2023, I have filed the section, my lord, the application was filed in 2020. 2020, AP 196. We are in 2025 today. The lordship, the conclusion is coming today of the section 34. So it should be commercially thought. And I don't find 9% compound interest commercial rate is something which is improper at all. And the period is also correct, because, my lord, I showed since there is no limitation, so obviously it will go back to the date from when he has not paid. That's 2004 where the last payment is made. Interest would be from 2004. That the records will prove. Lordship will not go into it because no evidence is laid for.
Mr. Banerjee, after lunch.
Well, I have already finished, my lord. I'll take 5 minutes to deal with if Justice Bhattacharya's judgment or justice. Or I can come back after lunch for 5 minutes, my lord. I'll come. Oh, oh. But maybe can I come back tomorrow early morning at 10:30, my lord, for 5 minutes?
What happened?
My lord, at 2:30 I have to be at NCLT, my lord. That is why.
Let's finish it.
Finish it. May I just? My lord, kindly sees that judgment of my lord Justice Bhattacharya as far as 36(2) is concerned. But I would say this judgment on the face of it is per incurium. Because of the division bench judgment which I have given to my lord, which I gave a copy to them, Supreme Courts, all high courts, including our high courts, has said, my lord, that if I secure the amount to the total, there cannot be any order, my lord, not passing the order of my lord withdrawing it. This judgment does not deal with any of the Supreme Court judgments, any of the division bench judgments, my lord. None of them, my lord. It is a view of the concerned judge at paragraph 21. And in my case, I have given, my lord, the details that why I need the money. Now, my lord, singular, my lord, mail ID is shown. Now, my lord, just because I am, my lord, a small-time trader or a, my lord, a singular person, today, my lord, Tatas have, my lord, several companies. If Tata Sons requires money from Tata Motors, will it not, my lord, write to them? It can. So, my lord, here I have a proprietorship concern, I have a, my lord, partnership concern. If my proprietorship concerns write to, my lord, the partnership concern, this is not illegal. Absolutely not illegal. And that's exactly what I have done. So therefore, my lord, the question is not, my lord, whether the need is there or not. Whether, my lord, I'm securing to the total amount or not, which I am saying I'm giving an undertaking that, my lord, I'll secure the entire 50 lakhs or 55 lakhs that is there with the registrar and take it out. That's, my lord, the first judgment. Second judgment kindly sees, my lord, this judgment of Justice Banerjee, my lord, completely different facts of the case. My lord, kindly comes to, my lord, the paragraph that, my lord, page 3 from the top, which, my lord, Mr. Bose has read out. I'll read out from there itself. To put, my lord, every arbitrator in the same framework is perhaps not correct, my lord.
Which judgment?
Well, the same one Mr. Bose, my lord, had given. I will not give Mr. Bose another chance of reply on facts, my lord. So I'll not say a word more than what he has shown.
No, no.
So, my lord,
Documents you have placed, I will give
so those were there. He could have placed it earlier itself. They're part of my opposition. He could have placed it there itself. He has not annexed. I have annexed it. He shouldn't, my lord, rise up and, my lord, give a reply on facts, my lord. That does not go with Mr. Bose. Anyone, my lord, come. Let us, my lord, take that judgment of Justice Banerjee, page 3 at the top. That is exactly what Mr. Bose also read out. I want to read out that only, my lord.
Yes.
Over the 17 pages, that is the arbitral award of April 7, 2016, the first 16 pages covered the dispute as to whether the respondent could have independently pursued its claim against the appellant. Herein dehoused the claim lodged by the appellant against the Chinese party. The arbitral tribunal found that the respondent's claim against the appellant herein did not have to wait the outcome of the appellant's claim against the Chinese party. However, upon arriving at such finding, the heads of claim made by the respondent were set out and entirely thereof allowed without so much as a sentence by any discussion on head of a claim. Is this the same award as ours, my lord? In fact, my lord, he has issue-wise, document-wise distinguished why claims are maintainable, what claims are not maintainable, and why is it maintainable, why is it not maintainable. That's not the case. Now, my lord, kindly sees. It does not appear on a reading of the counter statement filed by the appellant before the arbitral tribunal that any head of claim was admitted. There is no recording in the arbitral award that the appellant herein conceded to any claim. Indeed, the counter statement filed by the appellant herein reveals a robust challenge to the several heads of claim barred respondent to the. On the contrary, I read out what Mr. Bose did not is when and how in the award the counterclaim has been dealt with by him. Alternative case has been made out by the arbitrator to show that if this is allowed and he concedes, therefore his counterclaim does not lie. Because, my lord, then there is no question of quantity and quality, my lord, which can come up. So therefore, to say that it has not been dealt with is contrary to the award. Here must be, my lord, in the facts of that case, there was nothing in the award. Without seeing the award, lordship cannot, my lord, derive or come to a conclusion that my lord, that and this is correct, because here lordship is seeing that it has been dealt with in the award in a manner, my lord, apropos the my lord, the documents which are there, which are marked as exhibit. Now, my lord, apropos that, kindly sees the last paragraph. In the light of the appellant's denial of every individual head of the claim made by the respondent herein, it was incumbent upon the arbitral tribunal to adjudicate upon the entitlement of the claimant in the reference in respect of various heads, and thereupon certain quantum thereof. The arbitral award is singularly lacking in such of the award. There is no whisper as to why the claimant was found to be entitled of any of the heads of claim, far less any hint of discussion on the quantum thereof. In short, the arbitral award has been completely bereft of reasons the claims are. So, my lord, in facts of that case, maybe. But, my lord, reading from the place where, my lord, he has considered, analyzed, concluded from our award, it's not so. Absolutely not so, my lord. Therefore, my lord, this has got no application at all to the facts of this case, my lord. My lord, accordingly, I bow, my lord, pray before. No, that too, Mr. Bose has agreed to. That is why he said that lordship's severance is allowed. That is what he said. But, my lord, I am not on that. I am on the entire award. My lord, that is why I say, my lord, apropos this, my lord, either lordship, if this is going to be prolonged, my lord, allows me to, my lord, secure and take it out. Otherwise, my lord, the
Well
award
said.
should be sustained, my lord. Grateful, my lord. Those are my submissions.
May I give a quick reply, or can
After lunch?
after lunch, please?
My lord, after lunch, I'm not there, lord.
No, no,
Kindly.
I want to rely on anything.
Your junior is there.
Maybe on another day because
Huh?
maybe any other day because my lord, I want
Finish it off. You know, you have
No,
taken
my
so
lord,
much.
this rising for.
some new points crop up.
No, no.
So which
I,
my lord,
I,
you have to
I,
answer, my lord, then my
That
lord,
lordship
I'll
will,
be
I'm
at
sure lordship will.
lordship will not permit me. I mean, if I.
No, lordship will, of course, if it is a point of law, my lord,
The
Mr. Bose
point
will
of
not.
not on facts, my lord.
not on facts. The facts you have pointed out.
They are nothing.
Yes, yes.
I mean,
I
that's-
only pointed out the documents.
Yes, I mean, I will also. I mean, yes,
After lunch.
I'm grateful.
Lordship, there are two matters, items 17 and 18.
We'll take it up.
We'll take it.
starts, my lord, just one issue, my lord, on the doctrine of severance, my lord, if at all, my lord, I am required, my lord, in carrying the judgment, my lord, this is only a possibility that, my lord, if your lordship finds that, my lord, part of the award is not, may I just rely on it?
Huh?
No, this is Gayatri Balaswamy.
I told, I mean,
Yes,
it
my
can
lord,
be
it is
severe
required, my lord.
if it is required. You want to, I mean, I don't mind. In fact, before this judgment, there's a judgment of my love, Nana, with Justice Bakru.
I've given a
Yes,
judgment on that.
you want that? I mean, I can give.
This is
You know,
just, my lord,
I mean, it says.
in case, my lord, to be on the safer side, my lord,
No,
because
I also agree. It can be severe. I mean, if you find a good part and a bad part.
so that is the only issue, my lord. If your lordship, my lord, requires, my lord, I just put it on record.
And it over, it's okay. But that judgment is before this judgment. You want, I mean, no, it doesn't look nice in the reply. I mean, the which judgment chilo na.
So if I may just indicate the paragraphs without placing it, my lord, perhaps that would. So the judgment, my lord, takes into consideration, my lord, three issues. My lord, first, my lord,
Just give me the
paragraphs.
No, no, just the paragraph.
Yes, my lord, there are three issues, my lord, your lordship will find. My lord, paragraph 1, 2, 3. My lord, the first issue here, my lord, is whether the courts, powers of the courts under section 34 and 37 of the Arbitration Council Act will include the power to modify an arbitral award, which is before your lordship. And the second, my lord, if the power to modify the award is available, whether such power can be exercised only where the award is favorable and a part of there can be modified. Now, my lord, kindly with this, my lord, takes paragraphs 44, 45, my lord, this is on the, and thereafter, my lord, in the concluding part, my lord, I'm not placing the entirety, my lord, the conclusions are there in paragraph number 85. All right. So, my lord, these are, my lord, rest, my lord, the facts are there, my lord, because lordship will also take into consideration, my lord, paragraph 55, 56, which says, my lord, to modify or to remit. My lord, this power of remand or to power of modify, my lord, has been discussed. But this is on the safer side, my lord. Yes, Mr. Boss.
Keep 55 and 56.
56. Okay. Power of remand.
My lord, Diana. My lord, incidentally, Diana, fortunately for me, it's discussed in paragraph 34 of that.
Yes, you had read it out.
I have read it out, but he wanted to rely on this judgment. I'll just read it once, if you don't mind, the same paragraph. My lord, if it is an sort of a vague award with little bit of hazy award, supplement reasons is possible. But if it is no reason, no, that's provided. Can I read that portion?
Yes.
Yes. When we consider the requirement of a reasoned award, three characteristics of a reasoned order may be fathomed. So we're talking about a reasoned award. They are proper, intelligible, and adequate. If the reasonings in the order are improper, they reveal a flaw in the decision-making process. If the challenge to the award is based on impropriety or perversity in the reason, then it can be challenged strictly on the grounds provided in 34. If the challenge to an award, this is important, is based on the ground that is unintelligible, the same would be equivalent to providing no reasons at all. My lord, it's saying that what can I can't give any example. I can't think of example, and the last portion is also important. My lord, the award needs to have regard to the documents submitted by the parties and the contentions raised before the tribunal, so that awards with inadequate reasons are not set aside in a casual manner.
Yes.
But there must be reason. On the other hand, ordinary, unintelligible are to be set aside. subject to party to do away the, therefore courts are permitted careful distinguishing inadequacy and unintelligible. Here I say not even unintelligible, no reason. My lord, this distinction between this IPay versus ICI, paragraph 37, it says finding and reasons. They make a little bit of distinction. You can see paragraph 37, my lord, this distinction. Here is a case of no reasons at all. Now, my lord, a number of documents were shown from the affidavit in opposition. I will make to, before I show you the opposition, my lord, not a single document has been referred in the award. So basically wants Lordship to act as the arbitrator and adjudicate on those documents. Now, if a material document has been ignored, that is another ground for challenge. My lord, it's not a question, so the award becomes based on no evidence at all. Yes. Remember that last paragraph that Sayong? No, this is a award not only took into account irrelevant documents, one ground, and no documents, no evidence at all. This is also a ground for challenging an award, my lord, under this section. So, my lord, I am not now, but I am a government body, so I have to also address on documents. Forget, my lord, side, although I'm not required strictly, my lord, to address you on that, but I will. See, and if now Lordship adjudicates on the documents, let us see what documents he has shown. Yes. My lord, 100, he showed first, and I will not repeat, it's not proper also. 106, he first showed me. My lord, all these documents are not referred, my lord, in the award. But nevertheless, since he has pointed out, yes, my lord, page, quickly I will show you. I will only show you the date. My lord, this is the date of 2003. Right. Now, my lord, kindly come to 109. These are the documents shown by him. My lord, this 106. Oh, sorry, my lord. 106, he says.
He said that 106, that 2003.
Oof.
2003 document.
109.
109.
My lord, 2006. Yes. My lord, 116. Yes. Now, my lord, this document he showed and says, now, kindly arrange to furnish bill-wise following heads receivable for necessary reconciliation at this end. My lord, whatever it is, it's of 2009, my lord, and this is not an admission letter. Yes. Nevertheless, not discussed. Nevertheless, I have never said, my lord, that your lordship doesn't have the power, my lord, assuming no bona fide claim should ever, just because of a fault of an arbitrator, that opportunity is always there. I conceded on that. My lord, although my clients do not want to concede, but that's the law. My lord, 114. My lord, 114, 15. Then went back, my lord, I don't know. I don't know why these are being shown. All
just indicate, these were shown on the issue of limitation.
This is, I am also showing.
Just to show that there is a chain of transactions within 3 years.
Right.
Till the date of the reference.
Right. So I am saying 114, 115. Mila, these are so-called letters of 2006. As your lordship, kindly come. 107 was also shown. I don't know why. Oh, yes. 107 also was shown. Are you sure? Yes. 107, Yeah, on a different, whatever it is, my lord, 2004, 2004, 2004, 2005, sorry, I can 5. Now, my lord, straight away come to 121. My lord, in 121, 121, my lord, this document is important. Kindly note that outstanding balance of your concern as per our accounts is as 15 lakh plus 40,000. Have you found that, Manoj?
Yes, sir.
Please arrange to confirm within 23rd. If there is any difference, please arrange to furnish purchase order wise receivable so that can reconciliation if now, Millard, 15 lakh 27,000 plus 47,000 comes to 15 lakh 67,000. If this document was indeed taken to be an acknowledgement and within period of limitation, it was first should have been referred to in the award and the amount shouldn't have been 21 lakhs. My lord, yes, this is what I had to say with regard to site. Now, my lord, what else? Oh, 124 was 124, yes. My lord, this is a 2013 document at, it's a demand letter, and you will find at 125
The amount is there.
that same amount of, my lord, this is their demand. They want this amount only. Very important. All those blockage and of those past, no mention, my lord, of damages side. Now, 129, my lord, is the demand letter, invocation of arbitration.
Yes.
Now, my lord, it is not acknowledgement of liability. My lord, the invocation of arbitration of that transaction of 2002. My lord, it's that transaction of 2002 demand letter. My lord. Then 132. 132 is my appointment pursuant to that demand letter. And they say, because I appointed an arbitrator, I accepted all claims. My lord, this is my appointment of arbitrator to adjudicate the dispute.
Yes.
An arbitrator, I believe, adjudicates also a question of limitation. This is the invocation. So, my lord, these are the documents. But the more fundamental thing is none of the documents have been referred, my lord, to in the award. And Lordship is called upon now to act as arbitrator and do this, which, my lord, just one more point. Yes. Aha. My lord, if you look at the award, it's the question of interest. My lord, in the last portion, and he said this, where is the 34? Yeah. My lord, firstly, straight comes to page, and he read this. My lord, page 45. Hence, I award interest at the rate of 9% per annum compounded. My lord, previously he said there is no agreement for interest. Subject, I don't want to cite judgments. Compound interest, when you award any side, you have to give reasons why compound, etc. There's no reason. And what's more important, my lord, the damages have a reason from 2004 to 2006. My lord, you can see and read. And interest on damages, whether that's permissible or not, I will say the no adjudication, is from 2004. Now, my lord, the other point is more fundamental about this judgment. My lord, when there's a award without any reasons, or I challenge it because my counterclaim, those two documents, remember F and C, says they have been in challenge. My lord, irrespective of the question of severance and what should, if at all, you want to do, my lord, section 34(4), if you see 34(4), says when you are hearing an application under section 34, the court may, my lord, court may, upon request made by a party. Has any request come from them that there is acknowledged, there is no reason, therefore I will send it? My lord, this is one. My lord, one. Then, my lord, assuming your lordship takes it as a question, is it an oral request? My lord, these are sort of mind twisters, if I may, those with regard to our act, and these judgments come on, my lord, and I said, does it mention a written request or an oral request? Now, my lord, I take even oral because nothing is mentioned, say oral request. But the fact remains, no request has been made. Secondly, my lord, it must be remitted to that tribunal. I understand Justice Prabhat De is now chairman of Land Tribunal. There is, if you want, there's no question of being referred to him. So, but you can, if they make a request, not a request, if you feel that this application is to be dismissed and you find there's a claim, possible claim, you can leave parties to recourse to law, which means if I don't, either you force me to, I have to take instructions, which they can't even give instructions for me to give a notes so they will not delay the whole matter. So lordship is empowered, my lord, either to force me to agree to an arbitrator, which I say, I humbly say, I don't have the authority, my lord, being appearing for a government undertaking, but leave the parties which may, they may take recourse, my lord, to section 11, provided prima facie, which claims? Which claims? My lord, if your lordship asks me as a officer of the court, my lord, unpaid bills which he had raised, my lord, whether 21 lakhs or whatever, yes, whether it will be 15 lakhs because of the acknowledgement, or whether it will be 22 lakhs or side, not 22 lakhs, it can't be more than 22 lakhs. It's for, my lord, certainly needs adjudication on basis of documents. My lord, I think these are my submission. I'm sorry, my lord. The other judgments I couldn't, I wanted to give.
Need them?
My lord, you want, if you want on judgment, phrases like, I feel, 50-50, I told you, my lord, this is no reason not at all. If you want specific judgments on that, apart from that, I don't think
so, Mr.
I don't think
That is relevant. I think
Yes.
the lawyer should
Yes.
restrain themselves only to the award.
Yes. My lord, I also feel so.
I,
My lord, it's just that
I
they
don't
want.
need, the court needs to be told every day what are the powers of the court.
My lord, that's Sayong. It will otherwise start from.
You don't need to start from Sayong and then every day.
My lord, may I request something?
5
My
lawyers
lord,
tell
as a
me
lawyer, I'll be very unpopular. But whenever in a 34 comes, you pass a note direction that everyone must come with a 3-page note. as opening submission. I don't want anyone to come with full notes of argument because many things may be aside, but please make it aside. At least Justice Kapoor, when he was taking, said, unless there is a note, and contrary to the old practice of our court, I know your lordship is from Delhi, people come ready. So please make it as a practice direction. Otherwise, my lord, your lordship, and yeah, I didn't want to show you this something. Have you seen this section? And where do you? It's nothing to do with the matter, though. My lord, 34(6). It is putting a gun in your lordship's head that you have to dispose it of within 1 year. This is terrible. Sections are there. And this is why all this question of security came in. Because people didn't give any security, and the matter will get prolonged. And half of the matters, my lord, are all, I mean, 2 minutes, what do you need to, my lord, see, apart from the award?
Just the award.
So you please pass, I will be unpopular, but without, you should not even take section 34. A 3-page note as opening submissions.
Yeah, heard. Mr. Bose, you'll be filing your written submission?
No, that's so, but
within a week?
Takes it next Monday, my lord. By that time, we shall also
Yes,
file.
next Monday. Oh,
Within a week.
Short notes, my lord.
Heard. CAV. Parties are directed to file written submission along with all the relevant judgments they wish to rely upon within a period of 1 week.
Your lordship is not deciding the 36(2) now because your lordship is deciding the 34. No?
After this.
Yes, my lord, not required at all because either way it will go, my lord. That is why, my lord, I place this judgment.
What judgment? Oh,
so that I do not go empty-handed.
Empty-handed?
According to Mr. Bose, তুমি বলছো কিছু পাবো না। বলছি কিছু
No,
পাবো
no.
না।
Go to the arbitrator decide.
এটা গুছো কে আছে? আমি না এটা গুছো কেন থাকে?
Yes.
Lord, this is the matter, my lord, which I had apprised your lordship, my lord, where I am the award holder, and my lord, the award debtor has gone into CIRP, and my claim has been admitted. Claim has been admitted, my lord, with a rider that the admission is going to be contingent upon the adjudication of this proceeding. But I have the letter of the RP.
Where's the other side?
My lord, on the last occasion, Mr. Midhora was appearing, but my lord, I've met him. He said that he's no longer in the matter. My lord, he had intimated, my lord, in all fairness, he informed me that he had informed the RP. Now, the RP is not appearing, my lord. It is, my lord, I do not know if it is they are willing to proceed or not, my lord, because and they've not made the deposit of the 75%. My lord, lordship wanted to see those judgments on the last occasion. I'm carrying those copies. If lordship wants, I can place them. Lord, if they
Lordship, I am appearing for the RP in this matter. I beg to appear online. I'm appearing for the RP in this matter. The CIRP proceedings have been stayed by the Supreme Court by an order dated 12 September 2025, Your Lordship. And the Supreme Court is going to hear this matter on I'll just indicate the date 18th, Your Lordship. I'm kindly requesting you to adjourn this matter because the entire CIRP proceedings have been stayed.
My lord, may I have one subject to what your lordship feels, my lord?
What can we do if the
My lord,
proceeding?
if the CIRP state, my lord, that has no bearing on the section 34, my lord. That
But
can
what's
be.
the point of moving forward?
My lord, very well, lordship. I leave it to your lordship.
At the request of the parties, at the request of
My lord,
Learned
the
counsel for the
petitioner, my lord.
respondent.
That I am the respondent.
Award debtor, you're the award holder.
My lord, the award holder. My lord, the
Award
petition is at their behest.
Learned counsel for the respondent. Award holder states that the petitioner's company has gone into insolvency. The Miss So and so appears for the resolution professional and states that the present matter is pending before the Supreme Court. Full stop.
Your Lordship, the next date of hearing is 8/12,
It
2025.
states that the next date of hearing before the Honorable Supreme Court is 18th, right? 8/12, 8/12, 8/12.
8th December, Your Lordship.
The request for a short adjournment. Let this matter be listed on 17th December.
Grateful. Grateful, Your Lordship.
I appear for the respondent, my lord.
But I am appearing for the petitioner. These are my section 34 applications.
Yes.
Till date, they have not filed their opposition. If they do not wish to file an opposition,
Yes, my lord. All the, if the
this matter
records are there,
proceeded.
my lord, we do not wish to file, my lord. My
You
lord,
don't
I,
want to file it.
my lord, I'll seek indulgence, my lord. Mr. Banerjee is appearing as a leading counsel, my lord. If my lord keeps it not today, my lord.
But if they do not wish to file, then we can, my lord, this is a matter which has to be heard out. Section 34.
That's why we are sitting here, sir.
Yes, my lord, can fix it.
What fix it? It's listed on the. Is there
Yes.
on the list?
Yes, ma'am.
So start the argument.
My lord, may I come physically on another date and make the submission? So
At the request of the party, that this matter be listed. Let that this matter be adjourned to give a date after 3 weeks.
my lord, 13 and 14 are connected matters.
Same order, color. 12, 13, 14.
Grateful.
Consent দিচ্ছি না। My lord, on the last question, Mr. Banerjee said that
Which matter?
my lord,
15, my lord, I appear for the petitioner. My lord, on the last occasion, my learned friends, senior counsel, he asked me to give consent so that the award can be set aside and fresh proceedings may be initiated. To that, my lord, my instructions are not to give any consent. Let the matter be heard on merits. So, my lord, they can take directions for filing affidavits.
But in that case, my lord, all the records are not there. We'll file an affidavit, my lord.
Yes.
Or my lord can direct the arbitrator to file the records, my lord.
You file it.
We'll file it.
Opposition দেবে আমরা রিপ্লাই দেবো আমরা রিপ্লাই দেবো ওরা অপোজিশন দেবে আমরা রিপ্লাই দেবো আপা ये तो
This can be done. Why do you want to file?
My lord, all the records are not there, my lord. Some records, my lord, I have gone through the petition, my lord. There are some records
But do you
that.
need those records?
Yes, my lord.
Because it seems like this can be set aside.
But there is no section 21 notice even.
My lord, I don't want to take the burden of being citizen side.
And
Kindly keep it tomorrow,
unilateral
my lord. I'll
appointment.
take instruction. I'll take instruction and take appropriate steps, my lord.
You take instruction because
Yes.
this is
Kindly
unilateral.
keep it tomorrow,
as
my
well
lord.
as
We'll
two awards have been passed by the arbitrator.
kindly keep it tomorrow, my lord.
And that's suo moto. That's suo moto without giving it.
2 awards.
My lord,
Not today.
much obliged, my lord.
Tomorrow কালকে হবে Good.
Lord, I appear for the petitioner, my lord. Your lordship, this is my application seeking setting aside of the arbitral award dated April 26, 2024.
Who's on the other side?
Lord, Mr. John Lord, he appeared on the last day as well, Mr. Nilanjan Bhattacharya. Lord, today, Lord, may I pray for one thing, Lord. This application has been filed, Lord, beyond 90 days, but within the condonable period of 120 days, Lord. May the condonation be allowed, Lord. I shall serve him the notice that this matter is appearing, Lord. Prayer in terms of prayer A. All the arbitral records have been annexed to this application. Still, if they choose to file affidavit, Lord, I don't know.
How much is the delay?
Lord, the delay is, my lord, 21 days, my lord, after 90 days.
You inform him. We'll have it tomorrow.
Very well, my lord. Grateful.
Not today.
May I please, your lordship? Lord, 11th November, Lordship, I had substantially heard this matter.
Yes, ma'am.
I had two preliminary objections about the territorial jurisdiction of this honorable court and the stage at which this section 34 can be filed, because their challenge is to the rejection of their amendment. These are to my preliminary objections.
May I seek to satisfy me? Lord, first, may I start by tendering my unconditional apologies for being absent on the previous day when the matter was called on. Second, Lord, my learned senior friend has raised three objections as far as I understand it. The first is that there was a venue clause in the arbitration agreement, and that venue was admittedly Bhubaneswar. It is my averment that that venue was waived by the parties. I shall deal with the points on maintainability as well also. He then says that there can be no waiver of such clause in terms of the agreement, because the agreement says that there has to be a written addendum for such waiver. That is issue number one. Since that is issue number one, my filing of the section 34 application before this honorable court is incorrect. That is just for the purpose of filing of the section 34. Second is, he says that the order that I am assailing is an order rejecting my application for amendment of my statement of defense. Hence, since it's an order assailing an rejection of my application for amending of my statement of defense, I would have to wait for the conclusion of the proceedings for the purposes of assailing such order. May I, my lord? I am led by Mr. Gupta, my lord. I am seeking my lord's kindly.
Yes, Mr. Gupta.
Yes. Firstly, I'm really grateful for accommodating me that day and keeping the matter today, but I'm really grateful, my lord.
Yes.
My lord, there are two applications in my lord's list. One is a section 36 for stay. My lord, we have got the check. We can deposit that today. So, my lord, the
Shaking your head. You don't want to deposit the money.
To him, my lord, not to him.
Yes.
And the other is my section 34, challenging the interim award. Now, if my lord is pleased to take a look at the interim award first.
$49. Which page?
Yes, my lord. Kindly. But this is in volume 5. My lord is pleased to take a look at volume 5.
Volume 5.
Volume 5.
15 July order.
That is the section. That is the award which they are selling. Yes, yes. 15 July 24. This would be page number one.
There's no page. It is after 6.
It is after 699. We have annexed the certified copy. But firstly, your lordship would kindly take time. But your lordship would kindly mark at the first page 3 things. First, it's on a stamp paper of ₹100. The next page also is 50. So that is the requisite stamp duty one has to put in for an award, for an arbitration award. I am emphasizing on this because of a point taken by them that this is really not available for me to challenge in a 34. Second is, your lordship would see that it is on a stamp paper of West Bengal. Third,
Your Lordship would kindly note this, that this is an Indian Chamber of Council of Arbitration award. Right on that page, at the top. These carry some significance, and I'll tell you, Lordship, why. One issue which was raised by my learned friend is on the ground of jurisdiction, territorial jurisdiction. Relying on a clause of the agreement which mentioned venue and not a seat, mentioned venue to be Bhuvaneshwar. So, on the strength of that, my learned friend had submitted that, since the venue is mentioned, there is no seat mentioned. So, relying on two judgments, BGS Soma and the other judgments, the venue would be treated as the seat and the courts of that jurisdiction would assume jurisdiction. That is the submission. Kindly takes a look at the arbitration clause once. Kindly keeps this aside. This I would be referring because this is the award. Kindly takes a look at the first volume where the arbitration clause is there. Page 32 of volume 1, clause 14. Any disputes, differences, or has your Lordship got it, page 32, I'm sorry, volume 1.
Mr. Mitra,
Mr. Gupta.
can we hear this tomorrow? Because I'll take non-commercial matters at 3.
Yes, ma'am.
So let me stick to
Toyan Gupta, Mr. Gupta.
Oh, sorry, Mr. Gupta,
Yes.
sorry. Join though, right?
Chayan. Yes. Tomorrow, whenever,
Yes, tomorrow.
Because my learned friend is coming from Delhi, that's why, we had tried to mention before the rise.
You're here tomorrow or you're leaving?
I have my flight at evening, Your Lordship.
I can submit, subject to what my learned friend thinks fit. I can submit. If he needs to give reply, he can
I will not take much
on
time,
any
Lordship.
subsequent day, or he can join online whenever. Because I would be taking an hour at least, because there are a lot of judgments cited by them, lot of points taken by them. So I need to meet each and every. So at least an hour, I would take. So if I could give reply tomorrow, any day subject to my learned friend's convenience, he can give the rejoinder to that.
Yes.
Tomorrow he can argue, Lordship, will take down notes and will come and rejoin subject to Your Lordship's board permitting that.
So let him make his submissions and
I'm sorry, Manu.
You'll make your submissions. Shall we make him? I mean, he'll make his submissions and then.
Yes, whenever, Manu.
I can do that, Lordship. I will not take much time.
So tomorrow, let me submit. Then, whenever my learned friend, either tomorrow or any day convenient to him, he can rejoin, Malad, with regard to that. Because I would be taking about an hour, Malad. I should take about an hour.
Or we can give another date. When do you want?
Lordship may fix a date, then we can come and argue. I mean, if Lordship can give a fixed date, I can come and
But then
argue.
one thing I can do, I can also share the judgments which I shall cite beforehand, so that he can get ready on that, and on the next day then this can be done. But any day barring this Thursday and next Wednesday, my lord, I have two matters fixed outside, my lord. Any other day, my lord, subject to my lord's business permitting.
Next month. If Lordship, the 24th is okay, 24th November 4th.
Okay. At the request of the parties, let this matter be listed on 24th.
Lordship may keep it on 25th. I'm so sorry.
25th.
25th.
25th, I'm traveling to Delhi. Okay. Definitely right. Okay.
25th.
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 But could I put in the check, my lord, because the interest would be mounting. So,
That,
without prejudice to the rights.
That
of
is
the
in 36, that
36,
application. What do you think? We'll take the check.
Lordship, because there is no stay.
Oh, so that is why I want to pay, and
they want to stay.
I want to stay.
By
I have
saying
to
that,
pay. I cannot enjoy it free.
Lordship may decide 34th. That will in effect decide the 36 also. Today, Lordship may not accept that.
Interest is counted till today in the check. So, my lord, I was.
Fine, Lordship, it can be again counted. I mean, there's no hindrance to that.
We'll have it on 24th.
Well,
25th.
25th, sorry.
Great.
Not both the matters. No?
Both the matters.
I'm so grateful.
Non-commercial.
Item number 1. What shall matter?
Item 1, who's there? Not today.
I appear for the award holder, Lordship, of this matter.
But I'm also determined.
Well, there was an award passed by the London Arbitrator, Lordship, in our favor, Lordship, awarding a sum of rupees 5 crores and odd, together with interest thereon, Lordship. As of today, Lordship, after much deliberations, Lordship, we have received a sum of rupees 5 crores 63 lakhs 72,787. So, my lord, the total dues arise as of 6.28 crores, and we have received 5.63 crores. So, my lord, as on today, as on 7th November, Lordship, the last date of payment, they are paid in 2 phases, Lordship. Firstly, on 23rd July of this year, and then on 7th November of 2025. So, as of today, as of 7th November, Lordship, a sum of 64 lakhs 52,069 is lying due and payable. Lordship, may I file on supplementary affidavit to this effect, Lordship, stating the facts? May I supply a copy of this supplementary affidavit to other side, Lordship? Initially, they didn't appear, Lordship, and numerous notices were given. Then, Lordship, the Assistant Commissioner of Central Excise was also called upon to appear before this honorable court. With the resume, Lordship, finally they paid in 2 phases such amount. But Lordship, the fact remains that the amount lying due and payable as of today, Lordship, comprises of 2 components. One, Lordship, the unpaid interest as on 7th November. That is the date of payment of them by them, Lordship. And the rest is on account of TDS. Lordship, it has been the view of the Honorable Supreme Court as well as the High Court, Lordship, that TDS cannot be deducted out of any decretal amount, Lordship. Once my claims culminate into a decree, Lordship, it becomes the date. And on that amount, Lordship, TDS is not applicable. In my most respectful submission, I have judgments in support of that, Lordship. If your Lordship may please want me to supply them.
My lord, if your lordship takes up their execution application, page 12, my lord, they have given them all calculations there, my lord. Total claim was there on 5 crores 55 lakhs that was paid. Thereafter, my lord, interest was due and payable, my lord, up to 23rd July 2025, that was 84 lakhs. We have calculated up to, my lord, 85 lakhs. That was also paid now. Now, my lord, question is that regarding TDS, my lord, the amount has been credited to their account, my lord. He will have to get this amount credited from the, my lord,
income tax department. It was TDS has been deducted, means money has been goes to his till of the company, my lord.
So
My
what is
lord,
left now?
my lord,
What is left? If the TDS has been paid, only the interest to an extent is left.
Interest.
The TDS would have been deposited to the government. I mean,
The law is, my lord, that
but they're saying
TDS,
they're cutting it.
it's wrong deposit. And my lord, Supreme Court as well. Supreme Court, my lord, not in respect of TDS, but this honorable court, in respect of TDS, has, my lord, said that no, it cannot be done. I shall show you, your lordship, my lord. That's the law as prevailing as on date.
So what?
And, my lord, about 9,000 square feet, maybe, my lord, 10 minutes walking distance from this place. They were occupying, they continued to occupy. The mean profit claimed was about, my lord, 67 rupees per square feet. I told the client that had it been anybody else, he would have claimed, my lord, at the rate of 500 rupees per square feet, would have obtained an award of 400 rupees. But the award is about 67 rupees per square feet per month. Still, my lord, the government did not pay. And, my lord, the interest accrued. This is the calculation, your lordship, possibly the affidavit has been given. Kindly come to page 7. The calculation, my lord, the first is awarded amount. Then, my lord, they paid the... Kindly give me a minute's time, my lord. I'll look into my papers. The award is of, my lord, 24th January 2024. Now, kindly look into, my lord. এটা করতে দেখেছি এটা নয় না না এটা তো আরেকটা স্যার সেটা গেল কোথায় 20th month sir yes so that's correction. Now page 7, my lord, I was placing the awarded amount 5 crore 40 lakhs. More than a year thereafter, my lord, they paid, my lord, 486. That is, they deducted, my lord, 10%. Which they could not have according to me. So the balance payable principal is 54 lakhs. Interest on the amount is, my lord, 85 lakh. Then, my lord, on 7th of November, they paid further 77 lakh. The total amount as on day due is, my lord, 64 lakhs.
Yes.
my lord, if your lordship, my lord, this supplementary affidavit now I have filed. Well, I have to check it up, go through it.
The government
In
knows,
addition,
my
my lord, entire amount.
You are paying
My lord, we have
unnecessary.
paid entire, my lord, kindly appreciate, my lord.
Oh.
As on last date of the order of the court, my lord, if your lordship kindly takes up the. Well, if your lordship takes up the execution application, the
Yes.
calculation was given by them, my lord, page 12. That was, my lord, up to 23rd July 2025.
Because we did not know that they would pay again.
Where on page? Which page are you talking about?
Page 12, my lord.
12 of what?
Execution, my lord. Execution application filed by them.
Page 12 of execution. Page 12 is the award.
Page 12 is
What
the
of the
award.
award?
Sir, what are you?
Not a supplementary affidavit dated, my lord, 24th July 2025.
Oh, that has lost its force. After that,
Today they have filed another supplementary affidavit where they are indicating the amount which is due is
Now, my
64
lord,
lakhs.
today they are filing and serve me on in the court. Therefore, I shall have to go
Sir,
through
this
it,
is-
then I will answer to your lordship, my lord.
You know what?
According to my
this
lord,
is all public money.
Yes,
The interest which you are paying.
my lord, we have paid the interest.
Sir, you have not paid the interest.
Well, according to the court's order, my last court's order, my lord, we have, my lord, on the last date, my lord, when your lordship, we are before the honorable justice, my lord, Sarkar, my lord, his lordship.
Show me the order, what you are saying.
Last letter order for them.
You come prepared by tomorrow.
Very well.
My lord, kindly take.
Come prepared tomorrow and do the calculation. Give him the additional this.
I have.
Yes,
I have.
My lord,
give the affidavit.
my lord, regarding supplementary video, my lord, I have to take instruction of the department. My lord,
Sir,
some time required, my lord, because my lord.
How much time required so the interest keeps accruing?
No, my lord, interest according to my lord.
Every day the interest is accruing.
My lord, according to my lord, interest has been paid.
According to them, it has not been paid.
Well, let them. They are saying, my lord, I should submit to your lordship, satisfy your lordship that we have
See,
paid.
that is the problem, sir. Because you keep taking time, the interest keep accruing.
My lord, kindly
Nothing else.
My lord, money has to be paid by the government from the exchequer of the government. My lord, they some procedural aspect.
And whose money? Public money? Interest?
Yes. Now, my lord.
Yes.
My lord, that is paid by the government. It is not that the government is.
So that's what I'm saying. That every time you are taking date, the interest
My lord, we are not.
is accruing.
My lord, question is that the payment to be made by the government through the, my lord, unless budget has been passed. My
Who's the concerned officer? You call the concerned officer.
My lord, concern officer was there lastly, my
You
lord.
call the concerned officer and put an end to this. Put an end to this.
My lord, what? My lord.
It doesn't matter to people. Wastage of public money. Date and time.
Well, according to their application supplementary.
Forget it.
Then, well, I need not to make any submission. Your lordship passed any order. If that be the show, my lord, court is does not
You
want
call.
to share
You
me.
call your officer.
My lord,
Listen, sir.
my lord, kindly appreciate.
First of all.
My lord,
First of
I
all.
have the audience. I must.
First of all.
My lord, I must submit to the court, my
Please
lord.
lower
I must
your
be heard
volume.
by the my lord. We are the court of justice.
Sir,
My lord,
lower
this is
your
the highest
volume.
court, my lord. I must be heard.
You must.
I must be heard, my lord.
Listen.
My lord, this is the highest court of judicature. I must be heard by your lordship, my lord.
Take down.
Unless I've
Court.
taken instruction from my client, my lord, how can I answer to your lordship, my
This
lord?
court in the execution petition which has been filed is against. When is the award passed, Mr. Mitro?
Yes. It's January 2024. I'll give the date.
Give me the dates. The execution petition has been filed against the award dated
24 January 2024.
24 January 2024.
There was a typographical mistake which was corrected on 28th of March 2024. Really did not, pilot, change.
All right.
So far as the main award was.
There was an award. There was a typographical award in the. There was a typographical mistake in the award, which was further corrected on
28th March 2024.
28th March 2024. Full stop. The execution. You had filed this petition.
The execution application was
The
filed
execution application had been filed
29th August 2024.
on 29th August 2024. Full stop. The awarded amount is 5 crores 40 lakhs 68,436. The department had paid 4 lakhs 86,061 lakhs 592 on 23/7/2025.
Gotcha.
Full stop. The balance principal of rupees 54 lakhs 6,844 was to be paid. Full stop. Interest on principal at the rate of 12% per annum from 28/3/2024 up to 23/7/2025 accrued to rupees 85 lakh 67,995. Full stop. The department had further paid an amount of rupees 77 lakhs 11,195 on 7/11/2025. Full stop. The interest on principal at the rate of rupees 12% per annum from 24/7/2025 up to 7/11/2025 has again accrued to rupees 1,88,425. Learned senior counsel for the petitioner states that the total net payable amount as on 7/11/2025 is 64 lakhs 52,069. 52,069. It is noted that the principal on the awarded amount has been accruing time and again, since the department is unable to put the money as to deposit the money as awarded by the learned arbitral tribunal. Full stop. It has to be understood that since the department has been unable to make the payments on time, the interest on the awarded amount has been accruing, and that the department is burdened with the same. It has to be understood that the said amount is being paid by the department only due to the laxity on the part of the department, and that the interest is accruing on the department. Full stop. Learned counsel for the respondent, who appears for the department, has behaved in an unruly manner and has raised his voice for not being given, has raised his voice and has stated that this court can pass any order as it deems appropriate. Full stop. This court is anguished to see that the interest of the government of India is being protected in a manner which is totally against the interest of the department. It is further noted that the interest which is being accrued is only due to the laxity on the part of the department in pursuing the present matter, which could have easily been taken care of if the counsel for the department would have been more diligent rather than being aggressive to the court and raising his voice, wherein he has been given adequate opportunity and time to make the awarded amount. Full stop. It is being noted that the plea and pretext of the government that the amount is being accruing and that they have already made the entire payment doesn't really reflect from the award, as well as from the fact that till date the execution petition is still pending. Full stop. A supplementary affidavit which has been filed by the petitioner is taken on record. Full stop. Learned counsel for the respondent department is directed to come with the instruction as to the amount which is still due and payable to the petitioner on ground of the interest, as well as any amount which is still payable to the petitioner. Full stop. The same shall be done within a period of 1 week, failing which who's the concerned person?
My lord, it's the Commissioner of CGST Barakpur Division.
Failing which the Assistant Commissioner, Barakpur Division
of CGST and CX Barakpur Division
shall be present in the court. It is further noted that the conduct of the lawyer is absolutely deprecable and the department should look into it. Full stop. It is made clear that if the needful is not done, this court will be constrained to take necessary action.
My lord, may I have a prayer, my lord, for filing any affidavit in the supplementary in respect to supplementary, my lord? Because today they have filed the supplementary, my lord, we need the instruction to file.
Come back with the instruction.
Lordship.
Now, what is your name?
My name is Uday Shankar Bhattacharya.
What is your name? Sorry.
Uday Shankar Bhattacharya.
Uday Shankar Bhattacharya. This court will be constrained to place this matter before the Bar Council of India. This court will be constrained to put this matter before the conduct of the council, Mr.
Uday Shankar Bhattacharya.
Uday Shankar Bhattacharya, before the Bar Council of India. If Mr. Bhattacharya does not respect and learn to conduct himself before the court.
My lord, kindly, my lord, delete this, my lord. I am undertaking, my lord, unconditional apology to your lordship, my lord. What I have, that is hot of exchange, my lord. Otherwise, my lord, I have no intention to malign your lordship, my lord. I appear.
That is exactly what you have done.
My lord, that is, my lord.
Whose money is it, Mr.
My
Bhattacharya?
mistake.
Whose money is it?
Public, my lord, we are trying to.
And what am I agreed with?
No, that is, my lord is.
Do I have a problem with you?
No.
What am I agreed with?
Yes, because the public money is, my lord.
Are you not aggrieved?
Yes,
Who's paying?
Certainly, my lord.
Are you not paying taxes?
Yes, my lord.
I am also paying taxes.
My lord, kindly.
It hurts our conscience.
My lord.
It hurts every individual who pays taxes.
My lord.
The conduct of the department.
My lord, communicated this order time and again to the department.
Why have you raised your voice? What for did you raise your voice?
That is my mistake.
Is the court saying anything to you?
No, my lord, I'm sorry, my lord.
Mr. Bhattacharya, I'm also here in this court.
My lord, I appear your lordship before on another bench also, my lord. But this is the first time.
Have you ever seen me?
No.
Taking it out on any lawyer?
No, my lord. Well, sorry, my lord. I am undertaking, my lord, apology, my lord.
Our heart really beats because the department is unnecessarily giving them money. Unnecessary. This is all government money.
My lord, I mailed to the department.
Awarded amount is a different thing. Interest, it is our money.
My lord is perfectly correct, my lord.
And you are just paying off interest and you want to file your replies. You want to take 2 weeks, 4 weeks. Why should I give you 4 weeks? I should give you 2 days.
My lord,
you'll say I have to take instruction from the department. I have to ask from Delhi. I have to ask from here. Is the officer paying? Are you paying?
No,
who's paying?
I have
taxpayer.
Yes, my lord.
Award he has already got. Interest you are gifting him. And you want to keep gifting the interest for next 2 years. And this court should be silent. I'm sorry. That's not me.
My lord is perfectly correct, my lord. My lord, what mistake I have done, my lord? Kindly, my lord, exonerate
At the
me.
last time.
My lord, kindly, my lord.
Mr. Bhattacharya, what are you getting agitated about? And I can shout much more than you can.
No, that my lord's absolute power is that we are addressing to lots of
Mr. Bhattacharya, sorry, this conduct is not appreciated.
My lord.
Not appreciated.
My lord. But that is my mistake, my lord.
Next.
All other words against me, my lord, kindly delete, my lord. Other words also in the other unruly behavior, my lord, kindly.
I've cut it.
Next, my lord.
I'm the last person to go against laws.
My lord. I'm grateful, my lord.
Next.
My lord, I'm appearing with the petition in this matter, my lord. Mr. Basu is leading me in this matter, my lord. He is appearing virtually.
Yes, Mr. Basu.
My lord, may I have the privilege to address your lordship, my lord, for the petitioner? I'm
Yes.
sorry, my lord. Today I'm at Kotok, my lord. I kindly permit me to my lord, appear virtually. This is an application under section 29, capital A, subsection 5 of the 96 Act, my lord, for seeking for extension of mandate of the arbitrator. My lord, 4 documents, my lord, though not needed, but still, my lord, my conscience shows, my lord, that compels that I should place to your lordship. My lord, kindly see page 14 of my
Just
lord's
give the dates, Mr. Basu.
Yes.
Appointment date.
Appointment date, my lord, lordship will find at page 14. Order dated November 24, 2022 by the coordinate bench.
Yes. First extension.
The first extension was granted, my lord, at page 61. The order dated February 19, 2025 at page 61. First one I said at page 14, then, my lord, page 61. Then, my lord, kindly comes to, my lord, page 118, the last minutes recorded by the learned arbitrator, where the parties were at addendum. Kindly comes to 118, my lord, the last minutes. parties were at addendum, my lord, that the appropriate application would be placed before this honorable court for seeking, my lord, another extension. The stage is that, my lord. Has your lordship come at page 118?
Yes.
My lord. I am informed that the time to publish the award as per the 96th Act is to expire this month. The advocates for the claimant submitted that they will be applying for suitable extension under section 29 capital A, and the advocates representing all the respondents record that they have no objection to such extension and will consent to the same before the honorable court.
All right.
Now, my lord, the stage is that, my lord, the claimant's witness action as is already over. The respondent's first witness, my lord, is being cross-examined by me. They told, my lord, that they would produce one more witness. Thereafter, my lord, it would be followed by the argument and, my lord, publishing of the award. And your lordship may kindly also turn to, my lord, page 11 of my lord's brief. We have
Page?
also page 11.
Yes.
My lord, we have given explanations also at page 24 that there are, my lord, the proceedings are going on, my lord, because 29A says, my lord, that there has to be some explanation. 24, my lord, lordship will find that. And 25, we have but they also said, my lord, in terms of section 2, small e, this court is the principal civil court. These are all, my lord. I would only pray, my lord.
Who's appearing for the respondent? Where's the respondent?
We have given them, my lord, notice prior to, my lord. There's a lordship knows, my lord, our rules say at the time of filing, my lord, we have to give them notice. The notice
Subsequently, if I may intervene, your lordship, subsequently, your lordship will
They
recall.
have been participating. It's not ex parte, right?
No, not ex parte.
No,
They are
participating.
participating.
As I
Yes,
said,
we have
my lord,
also further issued a notice as well through email. And they were present yesterday, your lordship, but
They were present?
yes, they were present, but today, my lord, they are not appearing.
And my lord, so far the participation
Take
is
it up
concerned.
tomorrow.
No, my lord, as a participation is concerned, as I said, my lord, that
Mr. Basu, we can take it up tomorrow. Let them
very well,
come.
very well, very well, very well. Whenever, only, my lord, so far the lordship's query is that their witness is
That's
being
all
examined.
right. Let them come tomorrow. We'll have it.
Very well, very well, very, very. Whatever your lordship feels. Well, let the matter be written in its own position.
Yes, yes.
I am grateful, extremely obliged.
Grateful.
Extremely.
Number 4 and 8 are interconnected. Your
I
lordship.
appear for the respondent.
Item number 4 and 8 are interconnected. Not your
4 and 8, right.
Your lordship, director officer to place both the records before your lordship, my lord.
There's a GA there.
My lord?
There's an application.
Yes. The 34 application.
Let my learned friend place. I will argue on the point of maintainability.
Yes,
There is
yes,
no
yes.
34 in the eye of law.
There are two applications before your lordship. One under section 34 and other is under section 36(2).
Yes.
Well, so far the 34 application.
34.
So far the 34 application is concerned. Well, this is filed in the year 2021 in a disposed of AP. And when this application was filed, I firstly say, my lord, this is a wrongly, this application has been filed wrongly. When this application was filed in a disposed of GA, no, my lord, objection with regard to the maintainability was taken at the threshold. Affidavits were complete. Matter was pending since 2001. When I appeared for the judgment data railway authority. In the meantime, they filed execution application before the concerned Alipur court. And whenever the matter was taken up before the executing court, they have said, we have prayed that the 34 application is pending, so do not proceed with this. They did not vehemently object, my lord, and time to time matter was adjourned. What happened, my lord? Last in the year 2024, in the end, my lord, they moved a revisional application under 227 before your lordship's court, before the appellate side, stating that the, my lord, execution application is pending for a long time. Unnecessary learned court is granting adjournment. Therefore, prayed for early disposal of the execution case. My lord, that was past expertise. We had no knowledge. Immediately after getting the information, we said wrote a letter. Please provide me the application so that we can take appropriate steps in the matter. In the meantime, my lord, the trial court was not giving adjournment, and they proceeded. Then, my lord, this I tell you, lordship, this application was filed at point of time I was not there. The previous learned advocate was filed this application. My lord, I advise file a section 36(2) application so that you secure the money, then you will get stay, and the 34 and the 36 will be heard finally. When I filed this section 36(2) application, then, my lord, they took a point before your lordship, before the other previous bench, my lord, that since this application was filed wrongly in a disposed of AP, this is not maintainable. Now, I submitted before your lordship's court that your lordship's court has ample power to convert this application as a regular AP commercial. Your lordship, my lord, court hold that very well. I am not immediately granting in stay. You file your affidavit and you come prepared to argue on merit whether this court has right to file any application, convert this application, a wrongly filed application into GA. Pending hearing, my lord, we have got an order. This is also your lordship. I am handing over one copy, another. And your lordship kindly peruse this. ওটা দিয়েছি, আগের দিনই দিয়েছি, এক্সট্রা আছে কিনা দেখছি, এটা এখন এক্সট্রা ওই তো এটা unreported IA GA4 of 24 in AP number 507 of 2019. 507 of 2019. Well, we find before the matter is heard out, we found an order passed by your lordship's court. Your lordship, may I place this order?
Yes.
GA4 of 24 has been filed in a connection with AP number 507 of 2019. AP number 507 of 20 was disposed of. Same case, similar case, my lord. Under such circumstances, this court is of the view that application under section 14(2) read with section 15(2) of the Arbitration Conciliation Act must be renumbered as an AP and not an GA. That should be also prayed, that should be in our case. Moreover, although there is a prayer for appointment of a substituted arbitrator, the application has not been described properly. The application must be corrected accordingly with regard to its description. Let this matter appear on such and such date. The petitioner shall serve notice upon the learned advocate who had appeared on behalf of the respondents in the earlier proceeding, as none appears despite of service. This is the first thing I submitted before your lordship's court. Extra copy me. This was my first submission. Then, as of date, they have not filed any objection to my section 36(2) application. Then I argued extensively on the point of authority of your lordship's court for conversion. And to that, my lord, your lordship's brief, your lordship will get a judgment.
Yes.
Reported in 2009 5 SCC page 162.
Then
36(2) তাতে আছে. Yes.
Yes. 2009 5. 5 SCC. Yes.
And your lordship kindly peruse, my lord, head note E.
Yes.
Inherent power of the High Court. Has your lordship got it, my lord? It is at paragraph 48. My lord, I am placing the head note. Has your lordship got it, my lord?
Yes, where
Inherent power of the High Court. May I place it, my lord?
Yeah.
Power to
Yes.
convert revision or writ petition to appeal or vice versa held where High Court has jurisdiction to entertain either an appeal or a revision application or a writ petition in an appropriate case, it can convert a revision application or a writ petition into an appeal or vice versa. Constitution of India, Article 226, 227, inherent power of the conversion, revision into appeal, convert revision or writ to appeal or vice versa, practice and procedure from the proceedings, power of court to convert one proceeding to another, need for jurisdiction in respect of the original proceeding, not one to which my lord converted. And my lord, head note F, res judicata applicability where revision against the finding of preliminary question has not been filed, held, though res judicata applies in different stages, the same proceeding, well, this is not applicable. But by showing this judgment, I want to submit before your lordship, my lord, this court also has the power because your lordship's court both having the jurisdiction to hear 34 and also, my lord, 36. Now your lordship kindly peruse. Apart from the aforesaid, my lord, your lordship, very open, often, my lord, this conversion is making in different stages, different. Now the question whether the similar inherent power can be exercised by before the original side of this honorable court. My lord, now your lordship, my lord, and your lordship kindly peruse, my lord, order 49, rule 3 of the Civil Procedure Code. My lord, on merit, the case has a checkered career according to me. They have enjoyed the property more than 20 years without paying anything. They have got award which is perverse, apparent on the face of the record, but I cannot argue on merits until and unless your lordship, my lord, convert this, my lord, this GA into AP. My lord, order 49, rule, my lord, 3. May I place it?
Just
Chartered High Courts. Heading, my lord, the Chartered High Courts. This is a Chartered High Court, that is why, my lord.
yes.
Rule 3. Application of rules.
Yes.
Which rules are applicable? The following rules shall not apply to any chartered high court in exercise of its ordinary or extraordinary original civil jurisdiction, namely Rule 10 and Rule 11, clauses B and C of Order 7. Next one, Rule 3 of Order 10, Rule 2 of Order 16, then 4, 5, Rule 5, 6, 8, 9, 10, 11, 13, 14, 15, 16, so far as relates to manner of taking evidence of Order 20, Order 17. Rules 1 to 8 of the Order 20, Rule 7, Order 32, so far as relates to making of memorandum, and Rule 35 and Order 41 shall not apply to any such High Court in exercise of these are not applicable. Now, your Lordship kindly peruse, my Lord, Section 120 of the Civil Procedure Code.
Section
120. Of the civil procedure. That provisions not applicable to High Court in original civil jurisdiction. This says, my Lord, the following provisions shall not apply to the High Court in exercise of its original civil jurisdiction, namely section 16, 17, and 20. Now, these three sections specifically not applicable in the charter and the but we are relying section 151 of the Code of Civil Procedure in view of the that too also and in view of the order of the decision of the Honorable Supreme Court, where the Honorable Supreme Court has observed that this court has power for conversion. These are the minor things. And by virtue of such inherent power, your Lordship has jurisdiction to convert DA, that I have submitted. That so far the power of applicability under latest patent is concerned, it is submitted that on the basis of the authority given by the Indian High Court Act 1861, the Crown issued latest patent dated 14 May 1862 establishing the High Court of the Judicature at Calcutta. Subsequently, the latest patent of Bombay High Court and Madras High Court was also established. They were identical in terms. Under clause 13, I have the clause 13, I can. Under clause 13 of the latest patent, extraordinary original civil jurisdiction has been defined. I am placing clause 13 of the original side rules. And I am reading and handing over to your Lordship. Clause 31. Let us put it. And we do further ordain that the said High Court of Judicature at Fort William in Bengal shall have power to remove and to try and determine as a court of extraordinary original jurisdiction any suit being or falling which within the jurisdiction of the court, whether within or without the Bengal division of the Presidency of Fort William, subject to its superintendence, when the Honorable Court shall think proper to do so, either on agreement of the parties to the effect or for the purpose of justice, for the reasons for so doing recorded on the proceeding as the said High Court. Now, my Lord, So far, the origin side rules application, my lord, the latest patent is concerned, this is, my lord, my submission. My lord, therefore, my lord, in view of these, my lord, provisions, and in view of the earlier order passed by your lordship's court, my lord, and your lordship knows that nomenclature is no matter. My lord, for the nomenclature, no case can be rejected. My lord, substantial justice is to be, my lord, done, my lord, in favor of the parties. But here, my lord, for the only for filing an application GA in disposed of GA in a disposed of AP, my lord, the authority should not be prejudiced and suffer. My lord, this is my submission before your lordship, my lord. Now, so far, this is my the power of convention of your lordship, my lord, this is my submission. So far, my lord, if your lordships alternatively hold that no, this court has no power and this argument is not applicable. My lord, I am relying now, my lord, a judgment of the Allahabad High Court. Here, my lord, challenging an order instead of filing an appeal under the Arbitration Act, my lord, 226 or 227 application was filed before the court. My lord, the Allahabad High Court, my lord, relying on several decisions. Take note of this.
What is it? You give me later.
What?
Not giving me copies unless.
If I cite the judgment, my lord,
Give a copy of the judgment.
May I place the judgment? ওইগুলো তো citation দিলে তো judgment দিতে হয় না।
No, you must give a copy also, sir. What is the harm in giving a copy?
এটাতে নেই, এইটাতে আছে।
What is the practice here? You only give the citation, not the judgment.
My practice is here, my lord, 41 years.
I'm just asking.
No, my lord, I tell you, lordship, but that is why I'm saying, my lord.
I'm saying, what is the
judgment cited, judgment. That is the practice, my lord. If I give the my lord, citation, then my lord, I need not give.
My
If I do
11
not,
years practice doesn't say so. I am 1/4, but my practice is giving a copy. How will I?
From original side, we are from appellates.
Oh, tale jani na side, but you are doing a matter.
if it is reported judgment, need not give. My lord, I have what I have learned from my eminent seniors, my lord, it is not given, my lord.
So how will he prepare himself if you have not given? How will he read it here? Then he'll take a date to come back and argue.
Immediately, my lord.
If you are just giving, no, just for my knowledge, I'm not questioning your 41 years. I'm just asking a practical question that if you are not handing over a judgment,
even if a judgment is handed over,
can you hear me, sir?
Even if
Can you hear me? Can you hear me? We also have a right to speak, I guess.
Always, madam.
The bar has a right to speak. We only don't have the right to write judgments. We also have a right to ask questions, put our views across.
Pardon, madam?
Put our views across to you.
Yes,
so
madam.
my view is.
Madam, we are before your lordship, madam. Whatever you, madam, we lose or win, no matter. We are bound by the judgment delivered by your lordship. That I have learned, madam.
That's a different thing, sir. I'm just asking a question. I'm asking a question that if you give a judgment, isn't it easy for the person to?
Easy. But it is not what we have seen, madam. This is not done.
That's all right. It's not done. If it's easy, let us make our life easy.
As you.
So that we can
Madam,
finish off matter.
We'll give it. I'll give it.
If you don't supply a copy, he'll come back tomorrow.
Madam, this was argued earlier. He has taken note of it today. Again, my lord, this is, my lord, not expected. My lord, matter was hard 2-3 days before your lordship, my lord.
So that's the reason why I'm saying we should cut short the 2-3 days hearing. Give a copy so that he can answer it right now rather than he taking the citation, going back, coming back again next day. Cut short. Make it easy.
I bow down to your lordship's observation. My lord, to that one only I'm adding, my lord, he came, he heard, he taken note. Today is also saying that I am not referring no new judgment. What I argued earlier.
So you should have provided a copy. It would have been easier.
As your lord. The petition has been, may I place this one?
Yes.
Heard the learned advocate for the parties and peruse the record. This petition has been filed challenging the order dated 25th March 2010, passed by the District Judge Agra in this case number such and such Union of India versus Bhular Construction Company, by which objection filed by the petitioner under Section 34 of the Arbitration and Conciliation Act for setting aside the award dated 27th May 2002 given by the sole arbitrator has been rejected. Initially, this petition was filed under Article 226 of the Constitution of India, being C number such and such. This court, by order dated 3rd July 2010, issued notices. Thereafter, it appears that the case was listed on 22nd October 2021, wherein the counsel for the respondent number 1 raised an objection with regard to the maintainability of the petition under Article 226 of the Constitution of India. Later on, an amendment application was filed by the counsel for the petitioner for converting this petition to a petition under Article 227 of the Constitution of India. The said application was allowed by the court by order dated 21st of July 2022, and the petition has been converted in a petition under Article 227 of the Constitution of India. When the matter was taken up, an objection was raised by the learned counsel for the respondent that against an order passed under Section 34 of the Arbitration and Conciliation Act, rejecting or allowing the objection filed against the arbitral award, an appeal lies under Section 37 of the Act, and therefore this petition cannot be entertained even under Article 227 of the Constitution of India. Learned counsel for the petitioner relied upon a case being matter under Article 227 number such and such, and the case reference they are decided on 3rd October 2024, wherein this court has taken a view that a petition under Article 227 of the Constitution of India challenging the order passed by the arbitral cannot be entertained. It has been submitted by the learned counsel for the respondent that since the petitioner has statutory alternative remedy under Section 37 of the Arbitration and Conciliation Act 96, this petition may be entertained. Confronted with the argument raised by the learned counsel for the respondents, learned counsel for the petitioner submitted that it is correct that petitioner has remedy by filing an appeal under Section 37 of the Act 1996, but further submitted that since the petition has been entertained by this court, therefore he may be permitted to convert this petition into an appeal filed under Section 37 of the Act, as the jurisdiction to entertain an appeal is also with the High Court. Learned counsel for the respondents further submitted that such a permission cannot be granted, and proper course for petitioner is to withdraw this petition and file an appeal wherein he may seek for condonation of delay in filing the appeal, taking recourse under Section 5 read with Section 14 of the Limitation Act. Learned counsel for the respondent in this regard relied upon a judgment of this court in cases of Rammolal Brijbhushan versus Union of India, reported in 1980 SCC Online, all 319, my lord, wherein relying upon the Supreme Court judgment in case of Vishnesh Kumar versus Santi Prasad, reported in 1980 all CJ, this court has rejected the prayer for permission to convert the revision into writ petition. This court, in the case of Kailash Chandra versus Ram Naresh Gupta, reported in 1982 Allahabad CJ 608, held that conversion of a revision into a writ petition is permissible. The judgment in case of Vanish Kumar was distinguished by this court. Paragraph 3, 4, 5, 6, 7, 8, 9, and 10 of the judgment in case of Kailash Chandra versus Ram Naresh Jadhav. Now, should I read this or?
No, it's okay.
Relevant portion, my lord, quoted the judgment. Now, your lordship kindly peruse page 5, my lord, paragraph 8. In case of Raja Gopal, alias R.R. Gopal and another versus T.N. and others, reported in 1995 SC 64 in paragraph 27 of the Honorable Supreme Court held. Lastly, we must deal with the objection raised by the respondent as to the maintainability of the present writ petition. It is submitted that having filed a writ petition for similar relief in Madras High Court, which was dismissed as not maintainable under a considered order, the petitioners could not have approached this court under Article 32 of the Constitution. The petitioner, however, did disclose the above fact, but they stated that on the date of their filing the writ petition, no orders were pronounced by the Madras High Court. It appears that the writ petition was filed at about the time the learned judge of the Madras High Court pronounced the order on the office of his objection. Having regard to the facts and circumstances of the case, we are inclined to throw out the writ petition on the same ground. The writ petition can also be and hereby treated as special writ petition against the order of the learned single judge. In view of the case law discussed, I am of the opinion that there is no impediment in the case of a particular kind of proceeding is not maintainable and a different kind of proceeding lies in respect thereof. The court has jurisdiction to convert one into subject to limitation and court fees as the case may be. Thus, following the earlier decision of this court as well as the Supreme Court and established practice of permitting one particular type of proceeding to be converted into another, I permit the petitioner to convert this petition, Article 227, into an appeal under Section 37 of the Arbitration and Conciliation Act and grant him 3 weeks' time to do so. My lord, this is being done every time by your lordship's court in every high court in India, even the Supreme Court. And in view of this, my lord, I pray to your lordship, my lord, your lordship kindly direct the department to convert this, my lord, wrongly filed GA into AP commercial so that, my lord, we can come before your lordship and place the application for setting aside award under 37 and also, my lord, place the 36 2 application, my lord, because we are facing a very precarious condition. Whenever this, after filing, this matter was taken up for filing hearing, they prayed for adjournment before the lordship court and matter was adjourned. It was not hard, my lord, and we got also, my lord, adjournment in the court below. There was no problem. My lord, today is fixed for attachment of the bank account of the Southeastern Railway. My lord, your lordship, my lord, I am find, my lord, appropriate, my lord, protection of your lordship till the matter is heard out finally by your lordships and so that the matter it is not. Look, this is my respectful submission before your lordship. And your lordship has power, a lordship can do this, or my lord, in the worst case your lordship find this is not your lordship or give us breathing
The
time.
36-2 application has not been filed as the GA, right? Only 34 has been filed as the GA.
Only 34 has been filed. 36 has been properly filed.
Properly.
Tomorrow morning, my lord.
Tomorrow morning?
Tomorrow morning. I will address your lordship on 2 points.
See, this is what happens.
No,
tomorrow, my lord. I will just address your lordship.
Mind. I also
on
tell
2
your
points.
lordship, had
The
it been
first-
given, then also you
First,
have said
tomorrow morning,
that
I am not
Then I
taking
would
much.
force him.
Judges,
Two, I will be addressing your lordship.
strong enough to
First-
force that you have to argue immediately. Your lordship,
First-
I can, sir. Don't.
well, your lordship can, my lord.
Yes.
Well, in appropriate case, judges do, my lord. But normally your lordship are very
This court
gracious.
can, sir.
But your lordship are very gracious and accommodating us, my lord. We have seen in other court also, my lord. There is no problem. Had it been given, my lord, also, my lord, because one has to read it and one has to, my lord, distinguish it, my lord. That is why that is.
I will address your lordship on 2 counts. The
The
first,
prima facie, it can be converted.
I will
on
address
the-
on that first point whether the court has a jurisdiction to convert. And the second, if the court comes to a affirmative finding, yes, I have the power to convert, then whether this section 34 would lie in this court or not, whether the court has a jurisdiction to hear that, entertain, hear and take up that section 34 or not. I will address your lordship on these 2 counts. I will respond and I will show what is the proper law.
And one day what happened, I argued. He was in the, my lord, virtual mode, took note, and my lord, your lordship asked me, where are you? My lord, he vanished, my lord.
No, it was in the Barashat court. Barashat connectivity is poor.
Pending, and we are suffering a great, my lord, before the Alipur court, my lord.
Tomorrow morning.
Tomorrow 3 o'clock.
3 o'clock. Wait.
कौन सा आना है? KMCC हो जाएगा tomorrow फिर then morning is that
I'm grateful to your lordship for giving a patient here, my lord.
heard learned counsel for the petitioner list for further hearing. Peaceful.
May I file my opposition
to the section 34. 5 minute I am for the petitioner. Your lordship remembers that matter where my learned friend has taken the initial point of limitation, my lord. And my lord, I have given a calculation on the last occasion, showing it to be 118 days. Calculation, take it. My lord, there is another defense to it, my lord. I have filed a supplementary affidavit indicating, my lord, there was an issue. Days. Date of filing should be counted. So 90 plus 30, 120. So एक दिन कम हो रहा है. It's within time. 90 plus 20, 90 plus 30, 120 days. 120. This is 119. 119 days.
Leave it to your lordship, but I have one judgment.
No, 119 days, sir. The counting is 119. How are you counting it?
According to me, my lord, it's 122 days.
Sir, in September.
6th September, my lord. So
This is filed on 7th. Received on 10 September. 10 September.
10 September. They are saying received on 10 September.
10 September. Filed on 7 January. September you have 20 days. October you have 31 days. November 30 days. December 31 days. January 7 days. 119 days. Well within time.
But my lord, my submission is they are saying that they have received on 10th. But
There is no contrary evidence to rebut that. Sorry?
The correction of the award was made on 6/9. So 6/9 to 10th. My lord, there are gap of 3 days.
It is not on the date of
7, 8.
publication. It is on the date of receipt. That's the law. Date of the receiving it. Not on the date of publication. I'm sorry to say. Whether you have anything in contravention to prove that they have not received it.
No, my lord, I cannot prove. Only, my lord, I have one judgment with regard to they have seen the administrative defects, my lord. On that, my lord, I have won that administrative defect.
What is the need of administrative defects, sir?
It is up to your lordship.
I'll be humbly beseeching your lordship. There's one section 34, one section 36. Lord, I'll be coming back any day next week. I'll be doing my section 34, my lord. Because, my lord, now your lordship is hearing the section 34. There is no requirement for the 36 to be pressed upon. There is no execution application. So, there's no point, my lord.
May I submit, my lord? This is very rare that there is an award in favor of Union of India. It's a very small amount of 2,50,000, my lord. And my lord, if your lordship will decide, only waive the interest and let them.
But I am not agreeable to it, my lord. He says that I will pay. I am not agreeable
to file any affidavit in the to the 30.
I'll show from the award itself, my lord.
Kindly fix
Why is
any
it not
date, but
sustainable, my lord? Why is it contradictory?
The agreement was the termination was there. Arbitrator hold that there was a loss to the government, and that's why he
More so, my lord, the counterclaim has not been proved. A mere counterclaim of 2.59 lakhs. Arbitrator says yes. There are objections in the stay application. Yes, my lord. Stay, my lord, we are not proceeding, my lord. Section 36 I am not proceeding now. 34, my lord, I will. If I lose, I lose. He will execute it against me. If I win, my lord, the award is set aside. He's not pushing his 36 to. No execution as well.
Tomorrow, my lord, then. Kindly fix.
When do you want?
Day after tomorrow. Only one this time. Because, my lord, I want to prepare a short compilation so that, my lord, I can
Not
assist your
today, day
lordship, my
after
lord. Day after tomorrow, my lord.
Get on this.
May I file my opposition, my lord, or is not?
No, day after tomorrow.
If a copy may be given to so that when you're already give it. The lordship will only record that, my lord, the 34 is maintainable because
day after tomorrow, let's hear.
Number 6. 5 and 6, my lord. 5 is 34 and 6 is 36 too, my lord.
This is that matter, my lord, where I am for the respondent, the award holder, and I have said that they have wrongly filed this 36-2 in the ordinary commercial, ordinary.
My lord, sorry, my lord. I beg to appear on behalf of the petition.
Ask them to come back.
Yes, my lord. We have put an application for changing that, my lord, as being directed, my lord. Kindly make it not this week, my lord. We have put an application, my lord.
I only had one request, my lord, if it could be made time barred, because, my lord, I am suffering since 2006.
Next
award
week?
passed. Yes,
My lord, we have put an application in terms
After
of
a
the
week.
order, my lord.
After a week.
Grateful, my lord. My lord, actually, what is happening, my lord, since this system is very new, my lord, upload filing that we need to all took place. Neither our clerk nor the department, my lord. All this happened due to this, my lord. My lord, subsequent, my lord, as I have stated on last occasion, my lord, a coordinate bench of the Honorable Court has given direction in many matters, my lord.
For conversion.
For conversion, my lord.
From GA to AP.
Lord, if that be so, my lord, I know it's out of turn, but even the section 34, my lord, is filed on the wrong side.
That's why, no, AP from AP Com, that directions are there. I will produce those judgment. I have.
But I have not received any
No,
updated
since
letter
I have
on
written to the department to change it, if not, my lord, I will renew my prayer for my lord.
36-2 is also filed.
My lord, again, my lord, Honorable Justice Moushumi Bhattacharya's judgment is there that it has to be waived off of separate AP. Moushumi judgment is open.
Judgment,
My lord, that's why, my lord, I have stated very fairly,
and
my lord.
This
This is
execution as you have filed your
yes, my lord, my execution, my lord, in May it had come up when, my lord, the award debtor, my lord, had come forth and undertaken that they'll file a stay.
My lord, we have
in
filed.
view of that fact, my execution has been kept on hold.
My lord, we have filed
Otherwise,
36.
I had moved my execution in due time.
My lord, we have filed the 36. We are ready to secure the amount, my lord, in terms of the award, my lord.
Next week. Not today, next week.
Grateful, my lord.
I pay for the award holder, madam. This is a section in connection with the section 34 application filed in 2010. Subsequently, my lord.
Is your 36-2 application?
Yes, my lord. So, my lord, subsequently an execution petition was filed.
Secure the money.
My lord, otherwise, my clients have said that they are ready to. There is a small issue involved, my lord. The execution petition has been dismissed on the ground that the limitation was running.
You don't need this 36-2.
Well, I really don't need it. It will be to my advantage, but it will be a very
Draw the application.
technically, very morally, it may not be correct. But
if execution is not bothering you, then you don't need to press this application. You don't need to press the application.
This application, my lord, in my respectful submission, as it is, cannot be allowed. If lordship kindly takes the application, even the award is not annexed to the application.
Learned counsel for the petitioner does not wish to press the present application at this stage.
Great.
The same is dismissed as withdrawn.
Great.
Grateful, lordships. Keep looking.
My lord, then item number 10, I am for the petition.
Award holder, respondent, my lord.
Yes.
My lord, I am being led by Mr. Oriman Ray, my lord, currently online.
My lord, one thing may I submit, my lord. My lord, kindly taken up next week, my lord. I am not going to this voluminous document, my lord.
You should have done your homework before.
My lord, kindly, I am not prepared myself.
Not this week.
Much of
নামটা একটু রেকর্ড kindly recorded.
Not this week.
For the respondent.
File देना एक बार. Order sheet देना. Order sheet.
Then keep it tomorrow, my lord.
You are there?
I'm for the petitioner.
Yes.
I'm being led by Mr. Anirban, sir.
Item?
Item 11, sir. I'm the proxy counsel. The advocate on record is not present today.
Not today.
May it please your lordship, Lord. I am appearing on behalf of the petitioner. This is my application for setting aside of an award dated 21st of December
Who's on the other side?
2018. Lord, Mr. Aniruddha Mitra Milord was there, Milord. And on the last occasion, I had said that I will be doing this matter on Wednesday. But I came back today, Milord. I was actually traveling. So if your lordship pleases, I can come back on Wednesday. I have no difficulty. I got myself prepared a bit. As your lordship pleases, Milord.
Let's be fair to him.
Yes, surely. Surely. Let it appear on Wednesday, Milord. I'll inform Mr. Mitra.
Well, I appear for the respondent, Milord. I'm here, Milord. I'm appear for the respondent.
Wednesday?
Yes, Wednesday. Yes, Milord. Wednesday.
Obliged.
Obliged.
My lord, I beg to appear on behalf of the petitioner, my lord.
I
My lord.
appear for the respondent.
The service to service. Jira serve full My lord, we have served them with the copy of the supplementary affidavit, my lord, has been
On
directed.
occasion, Lordship, I have taken a point of maintainability that this is beyond the limitation. We have been served with the supplementary affidavit. If your Lordship kindly sees the supplementary affidavit and page number, Lordship.
Well,
Eight of the supplementary affidavit, Lordship.
In reply to your letter.
With that, Lordship, I would say the award is passed on April 5th, 2024. The same has been received April 5th, 2024. The same has been received by the petitioner Lordship on 12th April 2024 as per their pleadings in paragraph 1, Lordship. Now your Lordship will kindly see page number 37 of their application, Lordship, section 34 application. The section 34 application has been formed on 4th of July 2024 within limitation period, Lordship. But the same has been, Lordship, registered on 13th January 2025, which is beyond the limitation period, Lordship. We have, may I kindly show the registration case status?
with the leave of my lord, may I submit, my lord?
Yes.
Lordship. Now, Lord, the earlier occasion, what my learned senior friend submitted, that there was a defect which the department showed to the learned advocate on record, and thereafter, because of that defect, the same could not be filed within the limitation period, Lordship. Now, they have, because of such reason, the supplementary affidavit has been called for. Now, your Lordship kindly sees page 8 of the supplementary affidavit. The learned advocate on record wrote a letter to the learned registrar for clarification, and where the learned registrar has replied, Lordship. Lordship has gone to page 8.
Yes.
On the second paragraph, Lordship, the learned registrar replies that the above mentioned matter was presented before the central filing section in the month of July 2024. And soon thereafter, the same was also returned to your clerk, stating the defects found by the aforesaid department upon scrutiny.
Yes.
At the end of nearly 5 months, the said matter was again presented before the aforesaid department on 24th of December 2024 when it has become time barred. And thereafter the vacation started, and so the application has been registered on 13 January. So if there is a defect, Lordship, it has been informed to the learned advocate on record within the limitation period time, and they should have cleared the same within the limitation period within 21 days as per the rules, Lordship. And there is another fact, Lordship, that we have already filed one execution application on 23rd of December 2024 only, which have come up before this court on 8th of January 2025, when there was a direction upon the petitioner to file their affidavit of assets, but till date no affidavit of assets has been filed, Lordship.
Yes, sir.
My lord, as being replied by the learned registrar of the Honorable Court, my lord, it was presented before filing on time, my lord, within this limitation period. If my kindly place rule chapter 39 of the High Court rules, my lord, 39A, my lord, of the filing rules, my lord.
It has to be, the defect has to be removed in the time.
My lord, kindly take 6 only, my lord. Specific pleading says 6, my lord. Kindly take 6, my lord. Kindly take 6, my lord. Upon the presentation of a plaint, petition, memo of appeal or application at the central, a number will be granted to the presenter, my lord. So as soon as we present it before the filing section, my lord, it has to be filed within a number, and my limitation stops there, my lord. Now, my lord, learned registrar says that at the end of the January, it was not the case, my lord. My lord, my kindly takes page 9, my lord. Page 9 of my supplementary affidavit, my lord.
Sir, let us see the act. 34(3).
Arbitration Act. 34 though. Arbitration Act, वही तो रहो. Without books you have to. The section 34 खुला. ये tab भी खुला था.
90 days. Where is
plus
it?
30 days with
Plus 30 days. The
with,
photo,
my lord, we have put that, my lord. Kindly takes my pleadings, man.
An application for setting aside may not be made after 3 months, have elapsed from the date on which the party making that application had received the arbitral award. If a request has been made under 33, I don't see there is any provision for extension. This time barred, sir.
My lord, may I satisfy?
Filing has to be with removal of the defects. Nowhere gives you the liberty and the.
My lord, it was presented within the file.
It doesn't matter. It has to be removed. Defects have to be removed.
My lord, my humble
Defects
submission.
not removed.
My lord,
Anything which is filed
my
with
lord,
defects.
my lord, 2 submissions I will make, my lord.
Yes.
One, my lord, as soon as under chapter 339A, my lord, I present the application, they will give the number and the limitation stops there, my lord. Here, my lord, the department fails to give any number. And my lord, subsequently, my lord, kindly takes on 7th of October, my lord, they say.
Not correct. That argument I will not take. That you file it and you're given a number, the limitation stops there.
My lord,
not for 30.
There was no even 21 days, my lord. There was no communication, my lord. A defective application, my lord, is numbered and my limitation stops there, my lord.
34 petition. Sorry, sir. You have to file without defects. I'll not buy that argument. I'll dismiss on the ground of delay.
My lord, kindly allow me, my lord. I will come up with some judgments, my lord, to prove.
Come up with judgment. I'll dismiss it. I'm telling you, if there are no, I'm not convinced with the 39A, 39(6).
My lord, kindly records that there is one execution application pending. They have not prayed for any stay of this award, and they have
dismiss it. Then, madam.
Lordship, they have not also filed in affidavit of assets. There is a direction upon them to file.
That is a different petition.
My lord, that matter is not assigned to us, my lord. So I am unaware of. I've just.
That's not here.
It is not here in court.
Not today. Not today. Dates are very clear.
Unless until you show me some law and
Let
some
me,
judgments, I'm not gonna
kindly
entertain
put it in next week, my lord. I will.
next week.
Next week. Grateful, my lord.
My lord, I appear for the respondents, my lord.
My lord, I am for the petitioner. My lord, my section 34 application, my lord, award is dated 19th February 2025. My lord, disputes arising out of a development agreement. My lord, after the award has been passed and the application filed, my lord, parties have sat across the table. My lord, we are negotiating and trying to, my lord, settle the matter amicably.
My lord, I agree with the submissions made by my learned friend.
If your lordship
There is a
kindly give us some
possibility
time,
of
my lord,
us
we are hopeful that we'll come
Learned
back.
counsel for the parties, learned counsel for the parties submit that amicable talks are underway.
My lord.
And they are exploring the possibility of an out of court settlement. They pray and are granted.
My lord.
How much time?
My lord, any time in January your lordship keeps, my lord.
Let this matter be listed in the monthly list of January.
Great.
My lord, may kindly permit me to mention one matter, my lord.
Why?
My lord, in the morning today itself, my lord, we have mentioned one matter regarding filing of the written notes of argument. My lord has been pleased.
Yes.
Yes, my lord.
Give them. Ask the other side also to give the. ये भिजवा दे.